Deputy Commissioner Difu.
Difu. Then get your instructions. at
This
2 o'clock.
instruction dates back to 2016, but let me
Maybe
have the updated.
Ask your instruction as to whether the file is there or not.
Yes.
We'll take it up at 2. Get your instructions as to whether the file is there. We only want that. The file has been not traced. Does it take for 8 years for the file not?
Also, can it be after
At 2.
before rising?
Yes.
Before rising.
Item number 2.
Yes, Mr. Bora.
My lord,
What are you challenging?
my lord, I'm challenging the FIR.
Hmm.
The page, my lord, what you will find page 22, my lord. And the case has been registered under section 420 and 406.
Hmm.
And the petitioner is the Dharam Prakash Shah. What you will find his involvement and the whether the 420 or 406 has been made against him.
Hmm.
Apparently, there is no inducement and or deception on part, and there is no delivery of any money to him.
Page 20 is the FIR.
22.
Now, what is page 20?
That's the same, my lord.
Huh? That's the FIR.
That's my lord. That is by asking. That is the counter affair lodged by asking.
Okay. So let us see what is there in the FIR. Of,
Yes, page 22.
yes. I went to.
So that's the allegation, my lord. Page 23. As your lordship already seen, as per the FIR, the only allegation is against me that I have given the information regarding the availability and the everything. There's no allegation of any deception on my part, no allegation that the money has been paid to me either. And
What is this compromise agreement?
And that's it. There's a subsequently, there's a compromise agreement also, but they have filed in FIR also in spite of that agreement.
So whole matter is short is that Mr. Kusang paper and rupees 7 lakh in the bank account of Yah which was paid to council. So he filed another complaint also. Oh no, you filed. You filed the complaint.
I file a cross.
Now,
Now this is the prima facie, my lord, the FIR.
Hmm.
The cause of action arises as Assam. The case has been filed at Jharkhand. And there is no case of 420 and 406. And the 420, your lordship knows there has to be initial deception or inducement. Rather, he has approached it is
FIR has
FIR
been filed where?
in
Bokaro.
Bokaro.
You are challenging it here.
Here.
Why?
226.2 mile. Because the part cause of action here. Not only part and the actual entire cause of action belongs to this place.
You are relying on Naveen Chandra Majid here.
Yes.
Naveen Chandra Majid here, would it apply here?
Yes, fine.
Why?
Part cause of action, even then the High Court can exercise the jurisdiction.
No, in Naveen Chandra Majid here, there was a FIR filed at Shillong. Pursuant thereto, there was a requisition filed for a direction
Maharashtra.
upon that, for taking action upon that said FIR. And on the basis of that, the people from Shillong went to Bombay. And the Bombay, then he filed this particular thing. And these people wanted to arrest him out there at Bombay.
Not only, but there's a complaint in the Bombay, so the cause of action in Meghalaya. So that's then the matter went to the Supreme Court against the order of the Bombay High Court. Then this is the 226, whether the jurisdiction, the Bombay High Court has the jurisdiction or not.
But the fact that you have taken this 10,50,000.
Well, that's, but whether the 420, as the FIR goes, the 420, that has been given to somebody else in the FIR itself, not to me.
Maybe, but
But there has to be deception, my lord.
No.
I must
are
induce
you
him.
saying, Mr. Mora, that there is no case made out? Any criminal case made?
No, my lord. Because there has to be
We
inducement.
can't look into only on the ground of 406 or 420.
Then what are,
Maybe a case where you have to show that no criminal case is made out.
yes, in the FIR itself, the prima facie, they have to first make out a case of a cognizable offense. The 420, what are the requirements? The inducement. Whether I have induced, no. Rather, he has come to me for an information. I have simply given the information, you can meet so and so. Then accordingly, he paid to so and so. It's voluntarily. Neither that lady also induced him. Subsequently, returning the money, not getting the job, that is their dispute. And there has to be inducement on my part. And there has to be a fraudulent inducement. That knowing that I can't give you my job, even when I have taken the money, that would be a fraudulent inducement. So 420, there has to be the inducement first. Where is my inducement? Rather, he has approached me for getting the job. He has asked me whether there can be any person who can
No, it,
source.
okay, there might be another case of 420 or 406, but
Then
wouldn't
what
there be
offense?
any other criminal case?
See,
that we are
what?
taking into account that you have shown that you can get a job from backdoor entry by paying this 10,50,000.
Simply, I have said, I have not taken the money, no, where is the fraudulent? Which option, what offense I have created there? There has to be some offense. Which offense, under which statute, madam? Under which provisions of the law? There has to be an offense. First of all, cognizable offense to take an investigation.
No, if you become,
That I am not a public servant.
no, you are not a public servant, but if you become a conduit
Yes,
for the
conduit
purpose
of
of
whom?
committing an offense, couldn't that
Conduit,
come under?
there
the-
must be established that I must be a conduit. I am not
No,
a
that is
conduit.
the question of establishment will be there in the trial or in
The
the
prima facie
investigation.
to take a cognizance of an offense, that is the Bhajanlal. First of all, to register a case.
No, we are concerned with an FIR.
Yes.
Question of cognizance will take place. We are only as
No,
regards the
cognizance of
FIR.
by the police. There has a cognizable offense, I am saying. Cognizable offense when the offense made out prima facie case for the register a case. Where is the cognizable offense of 420-406 here? Take out the case, register a case. First of all, there has to be an offense.
Now, are you saying
Cognizable
that there is no? Are you saying that there is no case against the other person, Rajia or whatever it is?
Yes, there may not be also, because apparently
No, she has taken that amount.
The
Now
amount
she's not paying it
taken.
back.
that's there. And the amount is whether the fraudulent inducement and deception and the misappropriation by the Razia. That's a different issue, man.
No. If that is there, but if there is something to that effect that this particular person concerned has taken it, just that Rajia has taken it, saying that okay, I will give you a job, you give me
And
10,50,000.
No, that's not in the FIR.
That is the FIR.
No,
She
my
said
lord,
that-
Lordship simply see, as per his instruction, I paid the amount to so and so to backdoor recruitment process, but I was late by 2 days.
Hmm.
So Rajia has lost to charge me another 50,000, total amount paid so and so, so and so.
Hmm.
So he's voluntarily paid the amount.
Hmm.
Rajia, there is no inducement by the Rajia also.
Hmm.
Then what happened? Then I saw nothing is happening in the case of recruitment. I said to Mrs. Rajia Loskar, so and so, Guwahati-based Indian Oil, so and so, that I didn't want to continue. Then she told me that now it is not possible to return back the money. So, well, where is the case, pilot? So voluntarily he paid. Rajia has refused. He can go for a civil suit for that. If he has the document.
What is the stage of investigation?
Investigation has been stayed, my lord. By the order dated 21/4/17.
Who represents the state of Jharkhand?
There's a notice has been issued. It has been also served. There's a report also service regarding service.
Then
Nobody appears, my lord. On 18/2/2022, service been completed, my lord.
what do you say about the recent judgment of the Supreme Court?
About
is-
my-
The Chief Justice judgment? What is that? What's the name? About quashing of an FIR?
that the same principle still applies. There's no change of anything. The Bhajanlal still applies.
Original apply, but there that judgment says that why should this court interfere?
When there is no prima facie cause, court has to interfere. If there is no prima facie case, if there is a prima facie case, definitely court will not interfere.
No, the fact that there was a person concerned had taken money to
Yes,
give
I
job.
admit, my lord, that person, whether the taking money itself created an offense of 420, my lord, or a 406.
Any criminal offense?
No,
Taking money to give a
No,
job
no,
on back
there
of
has to be inducement, fraudulent that too.
that is only for 420.
Yes.
Are
on
you saying
of-
that there is no
for-
criminal case? There is no offense.
So if the public servant hasn't done it, the PC Act is applicable, 13. They are not public servant here. That if the public servant has taken money for the purpose of job, the matter would have been different. And against me, the petitioner, there's no allegation at all regarding conspiracy. All allegation against the Rajya. What is my role? My role is simple. Somebody asked for the information, I have given the information. That you can meet so and so. It doesn't create any that I was part of the criminal conspiracy. They have to make out in it that I was also part of the criminal conspiracy.
When you read this FIR, which has been the complaint you have filed before the Chief Judicial Magistrate, paragraph page 6 of the affidavit in opposition file.
They have taken a stay of that order. That's the affidavit.
No. Kindly see the complaint file.
Yes, ma'am. I mean, this is by us. This is by us.
Yes.
Page 6 onward starts. Ma'am.
Let's read from paragraph number 3.
Yes, ma'am. The month of January 16, the accused number so along with his friends Chandra Prakash Mahato, the accused number 2, who are the friends of the complainant, as both the accused person and the complainant studied in the same institute during the graduation, came to Guwahati for the personal work, and they met the complainant at Guwahati. Thereafter, they talked themselves for their employment. In the meantime, both the accused person approached the complainant while discussing about their career. The accused person said to the complainant they can manage the job for the job. The complainant, the accused person said the complainant that they can manage a job for the complainant in sale. As father, the accused number 1, this Krishna is working in the Hadar administrative post in sale, and the father was also power to give the satisfactory job in the state famous company. The accused person father stated before the complainant that the accused person are able to manage job in the state company if the complainant incurs an expense of 5 lakh only for the purpose of getting the prestigious job in the state reputed company to father of the accused number 1. It is in the other way.
So here the case is otherwise,
Yes,
where you have filed saying
Yes.
that
yes, rather I have been lured, I have been deception before 20. Alright.
Let's see Majidhia's case now.
My lord. Paragraph 22 and 37. Twenty-two first, my lord.
Yes.
So far as the question of the territorial jurisdiction with reference to a criminal offence is concerned, the main factor is considered is the place where the alleged offence was committed. Here the entire alleged offence was committed at once, as per their own admission. Then paragraph 37. The object of the amendment of the inserting clause 2 of the article was to substitute the decision of the Supreme Court of the Election Commission so and so to restore the view held by the High Court in the decision cited above. Thus, the power conferred on the High Court under Article 226 could be as well as be exercised by the High Court, exercising the jurisdiction in relation of the territory within which the cause of action wholly or in parts and it is no matter that the seat of the authority concerned is outside the territorial limits of jurisdiction of that High Court.
But was the FIR quashed?
There's a complaint, my lord.
It was not quashed. He was sent out here to Bombay.
Yes, my lord.
Problem which this court is facing is that there is nobody who is appearing for the Jharkhand,
So, my lord.
and it is on a deemed service.
18 to 2022, the service was there.
That's deemed service.
Yes,
Deemed service is different.
yes, ma'am. If necessary, we can take a fresh service. That's all.
Who is representing for the respondent? Number 4 and 5.
But for respondent number 4, Mr. S. Borthakur and R. Senthil appear.
Hmm?
For respondent number 4, Mr. S. Borthakur and Mr. R. Senthil appear, my lord.
Yeah, where are they?
They're both out of station today.
You are there? Now tell me. There's somebody out there. Tell me now. What is the, how are you dragging the petitioner?
I'm not very well aware of the facts, but otherwise, my lord, I have nothing personal against the present petitioner. But my lord, he had induced me to go and give the money, my lord, and that offense was done. There was an offense in the sense that money was taken from me, my lord, fraudulently. And my lord, that aspect has to be investigated by the Jharkhand police. The entire investigation is state, my lord. Whether he had any, I understand, my lord, the petitioner also is aggrieved by the actions of Mrs. Khatun, my lord.
Why have you filed out there in Jharkhand? That is the problem. Everything has happened here.
That aspect I need to
And
clarify.
Jharkhand police is not there. What is the state to say anything to that effect? Because I tell you one thing. If whether 406 or 420 is there or not, I'm not bothered with that. But I'm concerned with one thing. If there is any offense made out, question of quashing doesn't arise.
Okay.
Now, whether an offense has been made out in these facts, any offense,
Yes, Lordship. The money was taken from me, and with the inducement that a job would be provided. But that was I was cheated, my lord. There was no job actually. Just the money was taken, my lord.
what do you
And
say
that
about
money has
this?
been converted into for the use of the main accused person, my lord.
Who took the money?
Mrs. Khatun, my lord. Miss Khatun,
Miss Khatun took the money.
my lord. Razina Khatun. Or Razina Laskar.
And your allegation is that it is because of him.
Yes, my lord.
You paid the money to him.
Yes, my lord.
Now, would it be a case, any offense is made up against him?
My lord,
You didn't pay to him.
FIR would stand, my lord. FIR would stand because
If I would stand as regards Razia Khatun,
my lord,
but would an offense be there against him?
that would be a part of investigation, my lord. The degree to which the present petitioner was involved in the offense or not, that would be a part of the investigation, my lord. If not, if they're not involved, then there would be no, they would not be charge sheeted.
That is the latest judgment of the Supreme Court, that one. What is that? That name, some infrastructure or something? This is Chandrachud, paragraph 23. What is that judgment? Yes, Mr. Bora, you keep on doing criminal matters, must be knowing that.
That's not reported, man. That's not reported as far as
That is reported everywhere, it is reported.
regarding the which point, my lord.
On quashing of an offense.
Washing is that's the law, my lord. There has to be a prima facie
That
case.
judgment holds the field now.
That's the
Bhajan Lal
only-
is also two judges, this is also two judges, and that Bhajan Lal has been duly considered.
Yes, yes, if the Bhajan law is considered, that
What is that judgment?
remains the field, my lord.
What is
But-
that judgment?
That lordship will consider only the 420 has been made out or not against me.
Mr. Bora, I am not concerned whether 420, whether any offense has been made up. That is,
What offense has been made out, my lord?
I will look into it.
What offense?
I will look into it, Mr. Bora, whether an
Lordship,
offense has
if
been made
Lordship
up.
look into it,
Yes.
then I have no problem. Lordship can go in.
Yes.
Then Lordship can decide which they have registered in the 420. Whether my concern is whether the 420 has made out or any offense has been made out.
I'm only concerned whether any offense is.
Let us see which offense has been made out, under what statute.
Where is
My
that judgment?
concern is no offense has been made out.
Where is that judgment?
There has to be some offenses under a statute. There has to be some offense.
We'll take it up on Tuesday. You get the judgment. What is the judgment?
Is it Lordship?
What is the name of the judgment of Justice?
Which is the judgment probably Lordship. Central Bureau of Investigation versus Komando Hanna.
That is something to do with some realistic, some infrastructure or something.
Niharika is different.
Niharik.
But that's a different question regarding that's a no coercive action.
No, not on no coercive action. Niharika is the judgment where it says, what are the paragraph 20?
Paragraph
20. That is reported in AIR.
Yes, yes. Niharika is there.
2021.
Niharika been reported.
Yeah, Niharika is there. See paragraph 23. So when is Mr. Bottakot there?
So that judgment is the quashing and the no coercive action, basically. But the principle is same, still holding the fail, that it should not be used sparingly. But when there is no prima facie case,
No. Here, whether can at this stage,
yes,
where the court had initially stated, can the FI be quashed?
yes, FI can be
No.
quashed.
FI can be quashed, but can the FI be quashed in toto, thereby exonerating
Oh,
that person concerned?
Yes, and there's a one judgment. If there are 2, 3, 4 judgment, if there is no material against one in the FIR, it can be quashed. There's a one judgment.
Only against one.
Only against one.
What about the other?
Other can continue.
So
But
then,
there's
if on investigation something else is found,
Then
what will happen?
again, during the charge sheet, he can be roped into. That's the law. That's the law. But at this stage, he cannot be made an accused. But during investigation, subsequently something comes out. But today, he cannot be termed as an accused. That's the law. Future, if there's a material comes out, but in anticipation that tomorrow something will come, because the FIR, there has to be specific avertment against me. The specific avertment has to make out a offense. If there is no offense at all regarding me, that I have introduced someone so, neither there is an offense that they both have conspired together. There is no avertment to that effect also. That I also took a part, I have taken the money also, I have induced them. There is absolutely no material against me. And the whole thing has happened in Guwahati, they filed in there. So it's not a cause of action. The second part, the two parts.
If there is no cause of action,
Then the matter
can
has
this
to be.
court in view of Majid here transfer the case here?
Yes, so that's the High Court can pass the order to that effect. That yes, investigation has to be carried out in Guwahati.
Now, in view of paragraph 26 of Majid here, can this court transfer the matter out here? Because what is problem is that Jharkhand is not appearing here. And it would be difficult on their part to do the investigation here.
Jharkhand would be necessary because more than 1 year they have investigated.
But they are not appearing, what to do? And without seeing anything or hearing anything on them, becomes difficult.
My contention is very simple, my lord. When you register a case, there has to be a prima facie cognizable offense against me. I'm on that. And secondly, the jurisdiction. Yes, they can register it, but it will be a zero FIR. It's called zero FIR when they don't have the jurisdiction. Subsequently, they have to transfer it. That's the law. Second part. But I'm basically, if they have to register it, they have to find out is there any prima facie material against me in under section 420 or 406 which has been registered. Yes, the High
No,
Court can obviously
What do
see
you register? You register the FIR
with the section. With
with
the
the
section.
section.
Maybe sometimes section may be wrong. The High Court has the power that yes, it may not be 420, it may be 460 or for something else, but it has to come out from the FIR itself. There cannot be anticipatory evidence or anticipatory apprehension or hypothetical situation that where you can presume.
No, if there is a if in the FIR,
Yes,
there are some trivial statements being made, just as in this case,
Yes.
against somebody. But there is a strong case made against one person.
Yes.
The FIR can be registered.
yes, against him, my lord. Against him. But here the whole investigation carried out. So there is a judgment of this. I'll place it in the next day. That the FIR also can be segregated if there's no allegation at all. The investigation can be carried out. There's a Supreme Court judgment against the other. But after the investigation, if the fresh material comes out, the charge sheet can be filed against that person. There's no bar.
Show me that judgment.
Yes.
Then because this court finds that there is something against this Rajya.
Yes, Rajya I have because
There must
Rajya
be
is not
something
before us,
against
madam.
May not be nothing to do it because you came out here and said only that look here, you may go to this particular. Let's assume that everything is correct. He approached you, you said okay, you can pay somebody some money and you can get a job out there. That's all, and he approached and gave the money to her, and the money is not being returned by her. That is the case.
Yes.
At best. Now, whether that will constitute a case, a criminal offense against him. But if it is not, what is the scope of it? How can this court interfere?
I'll place the judgment.
Only that. And if not, the second leg of argument will be, can this case be transferred? If a case is made out, can this case be transferred here, taking into account paragraph 26 of Madhya?
Yeah.
Matter has been heard at length. List the matter again on 10th. 8th, there are a lot of matters. 10th. On 10th of August for further consideration.
After 10th of August.
10. Then there is no 10.
10th I'll be probably may not be enough.
See, when the
40, 50, up to 14:59 may not be matter. Can it be on 28, madam?
20.
28 of August.
No.
Then on 9th. 9th of August.
9th of August. 9th or 11th? 9th or 11th?
Okay.
11th, please.
Much of that.
Interim order passed earlier shall continue. Please.
Item number 3.
Yes, Mr. Chaudhary, what are you challenging?
My lord, a decision to forfeit my bank guarantee, which was deposited as a security in connection with a tender.
Then,
My lord, the facts are like this. There was an NIT, pursuant to which I submitted my tender. I had submitted a experience certificate, which on they tried to verify it. And on verification, the executive engineer there writes back saying that this has not been issued by us.
Hmm.
Based on that, they have lodged an FIR. Investigation, that is an independent proceeding going on. Now they have invoked the bank guarantee, thinking to take away 75 lakhs of my security.
Did you participate? You participated in the tender process.
Must.
And then merely on participation or the work order was issued?
No work order.
No agreement.
Nothing.
Only on mere participation.
Yes. And they have
During participation, he filed a fraudulent document, my lord. That's why.
Understood. But
That's
how are you?
As per the integrity pact, we have done that, my lord, which he has signed.
No, integrity pact, what does it say? That
It
you
says
can-
that if you submit anything to do any fraudulent document, we can forfeit the security deposit. And he was the L1 bidder, my lord. The committee had recommended him. Then later on, it turned out that the document was fraudulent. The experience certificate.
Now tell me whether a contract has already been there merely because he submitted.
No, the integrity pact is there, my lord. The contract, so far as the work, my lord, that has not come into force.
Integrity pact would be an undertaking.
It is in the form of an agreement, my lord, signed by both the parties. It
Do
is
you
a
sign the agreement?
It's a pre-contract integrity pact. my lord.
No. Do you sign that agreement?
Yes, my lord, we have signed it. That is what I find, my lord.
Show me. Where is the integrity pact?
Page 41 of the affidavit, my lord.
Page 41 is what you are saying.
There are two that page serially
No, running page.
running page.
Don't go by this page for these pages.
Sorry,
We
madam, we're
we
running.
don't have these pages nowadays. These are being struck off.
I do not have the running pages with me. my
Okay,
lord. It is annexure
pre-contract
E, my lord.
integrity pact. Yes.
Integrity pact signed by both, my lord.
MS Construction and Paran Soikia, Chief Engine Manager, Assam Power Distribution Company, acting.
My lord, internal page 3, lordship will find clause 3.
Hmm.
The bidder commits itself to take all measures necessary to prevent corrupt practices, unfair means, and illegal activities during any stage of its bid or during any pre-contract and post-contract stage in order to secure the contract or in furtherance to secure it, and in particular commit itself to the following.
Hmm. Will not offer directly or their intermediary any bribe, gift, so and so, so and so, so and so. Undertakes that itself. Where is it that he is not going to submit wrong documents? You are saying on that. Unfair, prevent corrupt practice, unfair means.
And
So
that will
giving
be
a
an unfair
false
means. He does
fraudulent
not,
certificate is an unfair means to obtain a contract.
he does not have the work experience.
Particular.
And then if your lordship comes to
it disclose the name
page,
and agency.
internal page 6 of the same document, my lord.
Hmm?
Internal page 6, my lord.
Earnest money deposit.
6.1 within bracket 2, my lord.
5.1.
6.1, my lord.
The earnest money in pre-construction or security deposit.
That is the deposit, my lord. 5.1 is the deposit. 6.1, 2, my lord. The earnest money deposit in pre-contract stage and or security deposit so and so shall stand forfeited either fully or partially as decided by the buyer. The performance certificate is annexure F, my lord. Page, that is the difficult part, my lord. I don't have the running pages.
Of that particular document.
That particular affidavit, my lord. Just after the document ends, my lord, the
Work done.
work done. Number 3, my lord, lordship takes a note, my lord. It is the number is given DAED so and so, so and so.
Hmm.
Then the letter of the government of Arunachal Pradesh, that is annexure D of that affidavit.
Mr. D. To inform you that the performance report in favor of current
The number tallies, matlab the package number and everything tallies. With reference to the above mentioned, it is to inform you that the performance report in so and so, so and so, so and so has not been issued from this office. And similar is the next page, my lord. It's an email.
Then you filed FIR.
We filed an FIR.
What has happened?
That, my lord,
No idea.
the documents were seized. There is a board meeting, my lord. Again, that was another affidavit was filed, my lord, the preliminary affidavit. The minutes of the board meeting is in that particular affidavit.
Board meeting of 29th of March.
23rd of September, my lord. It is in another, there is another affidavit, preliminary affidavit, my lord. Filed in 2017, my lord, 31/5/2017.
We give a preliminary affidavit. আছে নাকি? Preliminary affidavit আছে?
So there is an order.
And as per the notice inviting tender, inviting bids,
My lord,
is there anything as regards the preliminary pact or something?
it is
Integrity
there, my
pact?
lord. It is their integrity pact at page 26 of the writ petition. my lord.
Where? The bidder shall complete the accompanying integrity which shall be applicable for bidding as well as contract execution so and so.
Mhm. The preliminary affidavit is there, my lord. A second. After the affidavit.
I think. You are written affidavit.
Preliminary affidavit, it is there, my lord, in the file after the affidavit in opposition. 1st of June 2017.
So EMD was given by way of this 75
Recent-
lakhs
recent.
was given by way of bank guarantee.
Bank guarantee.
That is the requirement as per the integrity pact.
Integrity pact as well as the bid document.
Show me where is that because bank guarantee,
Page 16 of the writ petition, my lord, 9.1.
no, 5.1.
5.1 is the of the integrity pact, my lord.
Yeah.
And
While
9.1 is the,
submitting commercial bid, the bidder shall deposit an amount of 75 lakh as earnest money,
my lord.
security deposit with the buyer to any of the following, a confirmed bank guarantee. So this is how we have done.
This is how they have.
So at the time of submission of the commercial bid, one has to do it.
One is
So that you have invoked.
that way. Under the integrity pact.
Okay. Okay, Mr. Chaudhary, kindly come.
My lord, first your lordship will kindly have the facts. Relevant dates, my lord. One, the impugned decision is at page 55 of the affidavit.
855.
Internal page 55 of the affidavit in opposition.
Next, page 127. Okay. Running.
That running page, unfortunately, I don't have.
Okay.
At the very top of that minutes,
Hmm.
extracts of the minutes of APDCL board's meeting held on 29th day of March 2017. Your lordship will kindly make a note of this date. This date is of utmost significance.
Hmm.
So this is the decision. Just below that, your lordship will find the decision.
Hmm.
Forfeiture of cost of bid security for submission of fraudulent documents of performance certificate by Messrs. Paranjoti Soikia in tender specification number so and so, etc. The board, after threadbare discussion on the agenda, note, resolved to forfeit the bank guarantee amounting to rupees 0.75 crores submitted by Messrs. So and so for providing fraudulent documents against package number so and so. Now, this is the impugned decision. And the date of this decision is 29th of March.
27.
29th of
29.
March.
Yes. Then
And now, if your lordship will kindly come to the tender condition, which will show that on the date that this decision was taken, the integrity pact was not even valid. Their entire sheet anchor is the integrity pact. If your lordship will first turn,
what is the date of this integrity pact?
date of the integrity pact is
6/8/2016.
6/8. That is the last date of submission and opening
6/8/2016.
60
And it is valid till?
for 6 months.
Huh?
For 6 months.
Where is it?
Page, your lordship will kindly,
Shall be from the date of signing and extend up to 5 years or complete execution. What do you say about clause 12.1?
that is in respect of the successful bidder. 12.1.
Huh?
The validity of this integrity pact shall be from the date of its signing and extend up to 5 years or the complete execution of the contract to the satisfaction of both the buyer and bidder seller, including warranty period, whichever is later. This is only when the contract is entered into for execution of the contract. In case bidder is unsuccessful, this integrity pact shall expire after 6 months from the date of signing of the contract.
From the
Date of signing of the contract, which means this integrity pact. So, this was 6th of August 2016. This integrity pact is
no. It won't be, because if you see on top, the validity of the, wherever they are saying about this thing, this document, they are referring it as integrity pact. The validity of this integrity pact shall be from the date of its signing and extend up to 5 years, or the complete execution of the contract. Now, it doesn't say about this. The
No.
contract has been mentioned as that particular contract.
no, it cannot be for the simple reason. Why will a security be held if the contract is not awarded to the person? The logic is very simple. This bid security, it is in the form of a bid security that is taken. The term itself makes the position very clear. It is a bid security, because after that, the moment the contract is executed, a performance security comes. Bid security is only for the purpose of securing that in the meantime, during the course of a tender process, if there is any financial loss caused to the authorities inviting tender, that loss should be secured. Just to give a hypothetical example, madam.
But how do you take care of that wherever they mention, like, for example, or the complete execution of the contract
Well,
to the satisfaction of both the buyer and bidder, seller, including warranty period, whichever is later. So this is for successful. In case the bidder is unsuccessful, now again, this particular document is referred as this integrity pact shall expire after 6 months from the date of signing of the contract. Signing of that contract,
with
which has been given to the successful one.
how can one the simple logic can
Hmm.
there has to be my lord, this position will be clear from the tender clauses. If your lordship will kindly come to the tender clause, your lordship will first come to. I'll quickly place the relevant tender clauses.
Hmm.
If NIT starts at page 14,
Hmm.
and your lordship will straight away come to first the provision pertaining to bid security, that your lordship will find at page 30. 301.
Okay. Yes.
13.0 is bid security, and then 13.1. The bidder shall furnish as part of its bid a bid security in the amount and currency as stipulated in the bid document. The bid security must be submitted in the form provided in the bidding document. Now 13.2. The bid security shall at the bidder's option be in the form of a cross bank draft pay order bank guarantee in favor of the employer from a reputed public sector bank located in India to scheduled commercial Indian private bank as per the attached list only, list, etc., etc. Certified check will not be accepted. Bid security shall remain valid for a period of 30 days beyond the original bid validity period and beyond any extension subsequently requested under ITB clause 14.2. So how long will the bid security be valid? It will be valid beyond an extra period of 30 days from the date of the bid validity. So if the bid validity expires on 31st of March, this bid security will expire on 30th of April. Now, next, if your lordship will kindly come, this refers to 14.2, but before that, if your lordship will first come to 13.41.
Okay. 13.4.
Page 31. The bid securities of unsuccessful bidders will be returned as promptly as possible, but not later than 28 days after the expiration of the bid validity period. Now, thereafter, what will the successful bidder do is in 13.5. The successful bidder shall be required to keep its bid security valid for a sufficient period till the performance security pursuant to ITB clause 34 are furnished to the satisfaction of the employer. The bid security of the successful bidder will be returned when the bidder has signed the contract agreement pursuant to ITB clause 33 and has furnished the required performance security pursuant to ITB clause 34. The whole idea is, my lord, the moment a successful bidder is shortlisted and the contract is entered into for execution of the work, he will replace the bid security with a performance security so that during the entire subsistence of the execution period, it is secured by the performance security.
So you are saying that the bid validity is 30 days after the bid validity.
Bid valid. Now bid validity is again in 14.0.
Uh.
How long will the bid be valid? Period of bid validity. Bid shall remain valid for a period of 6 months after the date of opening of techno-commercial part prescribed by the employer pursuant to ITB clause so and so. A bid valid for a shorter period shall be rejected by the employer as being non-responsive. Now, this 14.2 is what is referred in 13.1. That 13.2
Yeah.
in the middle portion, if your lordship kindly comes back to
So
that,
it will be 6 months from techno-commercial bid
plus
and
30.
plus 30 days.
Plus 30. Now, in what are the situations when that period can be extended is provided in 14.2. That gains utmost significance. In exceptional circumstance, the employer may solicit the bidder's consent to an extension of the bid validity. What it can do is simply solicit. The bidder may or may not extend it. The request and responses thereto shall be made in writing or by email. If a bidder accepts to prolong the period of validity, the bid security shall also be suitably extended. So there has to be an express consent taken. That consent has to be given by the bidder. Only then, in such an exceptional circumstance, it can be extended. Otherwise, extension is not the normal rule. It is an exception. Now, in this context, if your lordship now sees the dates, there is no dispute about the fact that the date of techno-commercial bid, which your lordship, if your lordship will kindly come to page 16.
1/6.
These are facts which are not in dispute. Clause 9.1. Bids must be delivered in single seal envelope to the address below at or before 1200 hours on 6/8/2016. So 6/8/2016 is the last date of submission of techno-commercial bid. Now, next sentence. Price breakup shall be submitted electronically. Late bids will be rejected. Next. Bid envelope, that is techno-commercial part, shall be opened on the same day. That is 6/8/2016. So the date of opening of the techno-commercial bid is 6/8/2016. So 6 months bid validity, which comes to an end on 5/2/2017. 30 days thereafter of bid security, extra additional period will come to an end on 5/3/2017. And it is in this context we have to understand that clause 12.1 in the integrity pact, because the integrity pact cannot go beyond the terms of the tender. Now, if your lordship, in the context of these clauses, if your lordship looks at the integrity pact, that particular clause, this entire position becomes very clear. And therefore, my first submission with regard to the integrity pact is, if they want to call it that contract of integrity, that contract itself was not valid.
And if you see the integrity pact,
My lord.
clause 5, internal page 45,
My lord.
outside page, running page 117.
My lord.
While submitting the commercial bid, the bidder shall deposit an amount of rupees 75 lakh
My lord.
with the buyer to any of this. So this is number 2 will come in, Bangarit.
My lord.
The earnest money / security deposit shall be valid up to a period of 7 months or the complete conclusion of the contractual obligation to complete satisfaction of both the bidder and the buyer,
Including warrant.
including warranty period, whichever. So this will apply to successful.
Successful.
In case of successful bidder, a clause would also be incorporated. We are not concerned. No interest shall be payable. Now, any breach of the aforesaid provisions by the bidder or anyone employed by it or acting on its behalf shall entitle the buyer to take all or any of to immediately call for a pre-negotiation. The earnest money in pre-contract state and or the security deposit / the performance bond shall be forfeited either partially or else shall not be required to assign any reason. To immediately cancel the contract if already signed. So you say that a security deposit which has been mentioned, or the earnest money which has been mentioned out here in the pre-integrity pact, pre-contract integrity pact,
My lord.
is the bid security.
Because it is the same amount of 75 lakh. Besides that, I am not supposed to deposit any other security. It is in the form of a earnest money deposit, which is a big security.
So you say that there is, if we read the other provision in a different manner, it would saying it to be from the contract, then it would be going against the notice inviting tender.
Because the whole purpose is, even if we look, rehearse this, generally, if we look at the purpose behind having a bid security, assuming there are 5 tenderers, one of them resorts to some mischief, or after the tender process has progressed substantially. So invariably, your lordship will find a clause in the tenders that if you withdraw or modify your bid during the course of the tender process, your bid security is liable to be forfeited.
Now
Because
let us see your bank guarantee which you submitted.
my lord, that bank guarantee is at page
35 of the report.
35 of the report. In fact, bank guarantee itself is at page 36.
Submitted the bid for performance of the contract for its by bidder withdraws the bid during the bid validity period specified by the bidder. In case the bidder does not withdraw, the deviation owed by him does not accept the correction to the within the specified time. Now kindly come to page 37. These are the conditions on which the bank guarantee can be invoked. I think these conditions would may be relevant. If the bidder withdraws its bid during the period of bid validity specified by the bidder in the bid form, which will be 6 months from the techno-commercial bid. So it will be, if you do it before 5/2/2019
70.
or 7, then if it is done, you can apply this. In case the bidder does not withdraw the deviations proposed by him, if any, at the cost of the withdrawal stated by him in the bid, and or accept the withdrawal rectification pursuant to the declaration confirmation made by him in the attachment declaration of the bid. Number 2, which is not relevant. If the bidder does not accept the corrections or arithmetically identified by the preliminary evaluation of the bid, not relevant. If, as per the requirement of the qualification requirement, the bidder is required to submit a deed of joint undertaking and he fails to submit the same, duly attested by the notary public of the place of the respective executants or registered with the Indian embassy or so and so within 10 days from the date of intimation of the bid, not relevant. In case the successful bidder, if the bidder fails within the time limit to sign, we are not concerned. In any other case specifically provided for in the ITB, we undertake. So ITB does not say anything about that particular invocation. Let us see ITB, how does it say about, what do you say about the pre-intrigative pact? Kindly see page 26. The bidder shall complete the accompanying intrigative pact, which shall be applicable for bidding as contract execution, duly signed on each page by the person signing the bid and shall be returned by the bidder in 2 originals along with techno-commercial and volume 1 censored. Does the ITV in any manner show that the terms, that on the basis of the terms of the pre-contract integrity pact, you can invoke the bank guarantee?
There is nothing.
If it is not there, how can the bank guarantee could have been invoked? Going otherwise on other aspects.
That is there, my lord. Besides that, there are 2-3 further points. I'll address your lordship. But it is not as simple as it has been made to appear. My instruction is, there is some, even with regard to the work experience certificate that I have given, there is some miscommunication. That is my specific stand taken in my affidavit in reply. For that, they have already initiated. They have put the criminal jurisdiction in motion. That determination has to take place. If your lordship will kindly take up my reply for a moment with regard to this performance certificate, what I am saying.
So we are done with the dates.
Yeah. I have filed an affidavit in reply, my lord.
Yes, got it.
Para 8. That the petitioner begs to state that the petitioner categorically denies that the performance certificate indicating experience of work dated so-and-so is a fake document. The petitioner stands to the authenticity of the said document. The letter dated 23/9/2016 issued by the Executive Engineer, Daporijo Electrical Division, Department of Power, etc., which forms the basis for the respondents to hold that the petitioner had submitted fake experience certificate, is disputed by the petitioner. And the petitioner strongly believes that the same is an outcome of some miscommunication or some mischief played by someone to the prejudice of the petitioner.
Understood, but isn't it something else unless you show something very clear to that effect?
No, I'm not saying. I am, if your lordship poses that question to Indranil Chaudhary, I will say that I will neither believe nor disbelieve. That is why you have set the criminal action in motion. That aspect, whether I am right or the executive engineer of Daporijo is right, will come out during the course of the criminal investigation, the trial. But is it not premature for you to conclusively arrive at a finding to the extent that I have played fraud on you, and therefore you will invoke the bank guarantee without any actual loss having been caused me, without even putting me to notice? That is the other aspect, that besides what has fallen from your lordship and besides the tender clauses that I have pointed out, that it was beyond the purview of the tender condition. Even these aspects gain significance.
No,
You are
because,
taking a
because the imposition of the bank guarantee or earnest money as per the pre-integrity pact, more particularly 6.2 or 6.6b, states that you don't have to assign reasons. So where is the question of
No.
hearing?
Not to assign reason, but can they do it? That
But
is why
you may very well say that there is a question of partially also. You see, the invocation can be in full or in part.
Well,
So what is the decision for why not the full or part? There might be a case of.
I will substantially, I am with your lordship. But there is, when a citizen has invoked the extraordinary jurisdiction of your lordship, will your lordships not test it on the grounds of reasonable?
Which one? The
Whether,
integrity pact? On the integrity pact?
no,
Then
on the action that has been impugned, whether integrity pact, merely because it says that you may do it without assigning any reason, will that mean that it will be a case of no reason at all and your lordship will still allow it?
this
statement,
court can ask that why not 50% or half of it or whatever may be. What is the reason behind it?
on those, my lord, I'll place judgments. There is a judgment of this honorable court, division bench, and there's one of the Supreme Court also. One of the tests while invoking there are differences. When it comes to a bid security, it is basically to secure the tender process, that during the course of the tender process, no loss is caused to the authorities inviting tender. Once it goes from that stage and the successful bidder is identified and the contract is awarded to him, so far as the performance security is concerned, they can have a multitude of reasons. But here, the purpose is only for securing the bid. And just to hypothetically again give an example, assuming because of one mischief played by one of the bidders, the entire tender process gets delayed, or they have to invite fresh tender, there will be a cost overrun. To secure that kind of a situation, a bid security is normally taken. It cannot be for the purpose of an undue enrichment of the authority. They have not suffered any loss. They ultimately awarded the contract to someone else, and the contract must have in the meantime been executed. During the course of the tender process, they did not have to withstand any loss. So that will be the other limb of my argument. So my challenge to this is basically threefold. Number one, on the date that you invoke, the integrity pact itself was not valid. So you could not have, it had gone beyond the purview of that contract.
Mr. Chaudhary, why don't you argue on the other thing? The bank guarantee which was given couldn't have been invoked in these things
Yes.
because it did not permit you to, on the basis of the integrity pact. The bank guarantee only says if there is a violation to the ITP.
ITP.
ITP does not say anything as regards the violation to the integrity pact.
Exact.
And the ITP says the validity is on the basis of this 6 months plus 3.
I was coming to that aspect, Madam, but if I can satisfy your lordship,
Because otherwise to say the integrity pact is not valid, it becomes difficult for this court, taking into account the word used out there. More particularly in clause 12.1 or 12.2 says the word contract is being used for the purpose of that, the contract in question. Whereas the other aspect, the integrity pact,
it cannot be.
they have used the integrity pact as integrity pact, not as a contract.
But it is perhaps a mistake of the use of language, because it cannot be for the simple reason. Someone else is executing the contract. Why should my 75 lakhs be held up.
For
Otherwise-
6 months. For 6 months.
Even for 6 months, because the tender clause says that it should be returned as promptly as possible, not later than 28 days. If your lordship kindly comes back to the tender condition, if your lordship kindly comes back to that condition at page,
Now,
31.
what do you say? Now, why I'm saying there's a problem is that whatever maybe there's a contract entered into between you and APDCL
Mal.
as regards an intubative bag. There's a simple submission is look here, forget about the NIT or whatever maybe. They have given us a false document for which we have invoked as per clause 6.2. There is a contract, there is a valid contract. Who are you? Why this court should interfere in this regard? There is a valid contract. Now, the question, if we go into those, it becomes a problem for this court.
yes, yes,
But on the other hand, if we stick to the bank guarantee,
yes.
it becomes easier because they invoke the bank guarantee. And
Yes.
the bank guarantee did not say anything about the integrity.
Exact. That was my lord, my first attempt was to try and nip it at the bud, saying that it is not even valid. But that is what has fallen from your lordship is my second limb over. That's
Because-
the bank guarantee does not even
Because
speak about.
going into the question of the integrity pact, Mr. Deka will fight tooth and nail, saying that you see there is a contract. The contract, there is no challenge to the contract.
No,
So under such circumstances, they are liable to pay. Now, how do you link? Therefore, the question has to be from you is how do you link
the
the
bank guarantee.
integrity bank with the bank guarantee?
Bank guarantee. True.
And if you can't link it, you can invoke
Yes,
it.
yes, absolutely. Absolutely.
And the second point, what you are saying is, whatever may be, assuming that you can, then also, why there is no reasons given, there is no reasons required, but then also why you have invoked the entire one, not the 50% or 20% or whatever may be.
The logic has to be, it has, why does it say partially? Either in full or in part. The
Hmm.
reason is, it has to be commensurate with the loss suffered by the authority. There has to be some nexus with the action that has been taken. Unless they are able to satisfy your lordship that we have suffered this kind of a loss because of your fraudulent act or whatever you want to call it. Because of this, we have suffered this kind of a loss. And to compensate that, we are invoking the bank guarantee to the extent of this amount. That application of mine is not even there.
So that may give you 50% back.
But I have already suffered because that 75 lakhs has been lying with the bank since 2017.
Okay, anything else? I think that is enough.
More or less, I will just place, won't even trouble your lordship. This is a judgment of the division bench. Of course, this was in a slightly different context. This is a case pertaining to Food Corporation of India. Here, the tenderer, I'll just briefly indicate, Malak. Here, the tenderer, what it had done is, it had made some tweaked or made some changes. He said that I had submitted my tender in a hurry. Therefore, I should have quoted my bid against clause so and so. Instead, by mistake, I have quoted against this. So that may be treated to be like this. It went on like that for some time. Thereafter, my lord, beyond the bid validity period, now the authorities tried to bring in certain new aspects. So here he said that I am not agreeable. I am no longer interested. So he literally almost withdrew his bid. And they said that no, you cannot. We are invoking the bank guarantee. We are revoking the bid security. So
Mr. Deka, this type of case recently also happened with APDCL, na? The Justice Manish Chaudhary's judgment which went to the division bench, where there were certain terms and conditions which after the submission of bid, the APDCL wanted to import some more terms and conditions out there.
I am not aware.
Mr. KP Pathak was appearing in that matter.
Maybe.
Yes. And then the matter went to the saying that you can't import to these new conditions and you wanted to withdraw, invoke you have invoked the EMD in that case. Anyway, so this is similar to that.
in that context, my lord, our division bench has said that ultimate one of the tests is that have you suffered any actual loss?
Mhm.
Because you cannot, the authorities in the name of invoking bank guarantees or bid securities, they cannot it cannot lead to a situation of undue enrichment of the authority.
So you say that the invocation of the bank guarantee has to commensurate with the loss suffered.
And there is nothing in their pleadings to even remotely indicate that they have suffered any loss of.
Or even in their order. Of page,
Be it the order,
your page is this one.
page, my lord, 55 of the affidavit in opposition.
So they just invoke 75 left.
There is utter
So
non-application
reasons
of
is
mine.
not required. Reasons is not
Reasons
required for the purpose of invoking,
But quantification.
but only for the quantification, they have to assign that we have suffered this loss.
So these are primarily the three arguments.
So that you give it to the discretion of Mr. Deka as to how much he wants to take from you. Anyway, yes, Mr. Deka, I'll come in 5 minutes.
Right.
Part of the ITB, my lord. The bank guarantee will necessarily mean that if there is any violation of the integrity pact, my lord, then also the bank guarantee we can invoke. And further, my lord, regarding the validity, lordship has seen in the writ petition, the bank guarantee was valid till 4th of May 2017. In the bank guarantee itself, it is written, my lord, at page 37. The guarantee will remain in force up to and including 4/5/2007. And it has been invoked within its validity period. That is the next page, my lord, page 38.
No. Here the bank guarantee says in any other case specially provided in the ITB.
ITB.
Now does the ITB say that the violation of the integrity?
No, my lord, the ITB does not say.
Then?
ITB does not say that if there is violation, but the integrity pact is a part and parcel of the ITB, my lord. But the integrity pact specifically says that if you are responsible in depositing any false documents, my lord, then the bank guarantee can be invoked, my lord. But that has to be read along with the ITB, my lord. It is the part of the ITB. The ITB says that integrity pact has to be signed. They have signed it, my lord. No dispute. That is not under challenge. It's a contract, my lord, which empowers us to invoke if he files a false document. And now in the affidavit in reply, they dispute that it is not false. Then it gives rise to disputed questions of fact, my lord.
No, that I'm not touching. I'm not touching on whether the document so given
All right,
is
man.
right or wrong.
I'm not going to.
I'm not going into that because that this court can't go in. And in fact, they only dispute,
They dispute.
nothing more than that. We are not on that. But when the bank guarantee categorically mandates that these are the circumstances on which the bank guarantee can be invoked, and in any other case specially provided for in the ITB,
Yes.
meaning thereby, wouldn't it mean that it has to be in connection that the ITB provides invocation of the bank guarantee? Because the other, if you see the other 5, specifically says that these are the
Yes, if you do not-
circumstances on which the bank guarantee can be invoked.
My respectful submission, since it says that in any other case specifically provided for in the ITB, integrity pact is a part of the ITB. So while reading the documents, while interpreting the documents, my lord, lordship will read the integrity pact along with the ITB. That is my respectful submission. Because
But does the ITB say, the integrity pay, say about invocation of the bank guarantee?
no, the ITB does not say so. ITB does not say that
ITB only says about earnest money.
earnest money. That is the language used is different, my lord.
No,
No,
understood.
ITB says with security. It is the integrity pact which says earnest money.
No. Integrity pay says the bid.
No, no.
Earnest money says it is.
ITB says it is with
earnest money.
security, my lord.
Earnest money. Kindly come to page 117 or page 45. Earnest money.
Lordship is reading the
Your affidavit.
that is my lord the integrity pact.
Integrity pay
Integrity
only
pact is
says
saying earnest money,
earnest.
and ITB is saying bid security. But the amount is the same, 75 lakh.
Maybe the same, but it doesn't say anything about earnest money.
The ITB.
Yeah.
Yes, the word used is bid security. And if your lordship reads
And
this,
if you are doing it at the same time, why haven't you used the same words?
but the understanding of the parties is there, my lord.
Because you see, earnest money deposit in pre-contract state,
It is the bid security, my lord.
no, understood? And security deposit performance bond after the contract is signed shall stand forfeited either fully or partially as decided by the buyer, and the buyer shall not be required to assign any reasons therefore.
Yes. So whatever is there at the pre-contract stage is the earnest money. This is at the pre-contract stage, my lord. This is the earnest money. And if it is the performance security after the contract is signed, so if anything comes to our notice after the contract is signed, then also we can do it, my lord. That is 6.2.
No, that is what I read.
That is the clause. And regarding the loss, my lord, regarding the loss suffered, my lord, if your lordship kindly takes up the preliminary affidavit filed by us, my lord.
Hmm.
I don't know whether it is telling, my lord. I tried to.
Yes,
it-
yes, I saw it here.
Internal page, that is annexure C, my lord, of that affidavit. It is again a minutes of the board's meeting, my lord, dated 23rd September, my lord, on the same day, very same day when that letter came from the Arunachal Pradesh government, my lord. That it is a fraudulent document. Second page of that annexure, my lord. My lord, whether it is matching or not, I do not know. Maybe 109 page number.
Performance of no, preliminary affidavit, first page is the performance security. Second is the chief general manager saying that to
Yes,
the
my lord.
chief general
Yes,
manager
the annexure C.
and actor C, yes.
The second page of that document, my lord.
Hmm.
Number
Yes.
4, my lord, Roman 4. This is the package we are talking about.
Hmm.
The board considered allotment of works of supply, construction, and commissioning of so-and-so. Beneficiaries of so the board discussed the recommendation of TPC. TPC is the tender purchase committee. I'll show that minutes, my lord.
You are referring to which page?
Page 13 internal, my lord, second
Okay.
page.
Yes. Board
Roman
considered
4, my lord.
allotment of work.
Yes, my lord. Yes. Lordship may skip that part, the description of the project. Then, my lord, the board discussed the recommendation. Lordship has got it.
Hmm.
Of TPC1 and the appraisal note of GM so-and-so dated 22/9. As stated in the appraisal note, Sri Paranjyoti Soika, that is the petitioner, who in JB with so-and-so has been found to be the L1. He was the L1 bidder, man.
Hmm.
Had enclosed the performance certificate about his past experience along with the LOA issued by the executive engineer so-and-so. However, on inquiry, the concerned executive engineer so-and-so has denied issuing such a certificate. The CPM RDC has also by email dated so-and-so shown to the board informed that Sri Soika has not executed any project under so-and-so. It was therefore concluded that the bidder has manipulated the documents and had forged the signature of the above EE. The board, after taking cognizance of the matter and instructed CGM RE to initiate legal action against Sri Paranjyoti Soika and his JV partner so-and-so for providing false information and misleading the board. The board recommended that an FIR should be lodged in the regard. Further, the board opined for retendering of the package number so-and-so, as the other two bidders in this package were also found to be non-responsive. So it is not that, my lord, no loss has been suffered, my lord. The project has to be had to be retendered. The work. Because he was recommended as the L1 bidder, my lord, on 19/9/2016. These things came to our notice on 23rd of September, my lord, 4 days thereafter.
And when did you issue the board retender?
Retender, my lord, that is not available on record. That date, my lord, that I have to take it back when it was done. But the other two bidders were held to be non-responsive. That also minutes is there in the records, my lord. It's because of this continuous pagination, my lord, we're having some difficulty.
Hmm.
That is in the AIO, my lord, the affidavit in opposition, my lord.
Page?
Page 31 of that affidavit, my lord. Annexure C there.
Yes.
Then internal page 1, 2, 3, 4, and 5, my lord.
Hmm.
That is the tender. Lordship sees a table, my lord. Resolution number 4 dated 19/9. Lordship has got it. There's a
Agenda?
table, my lord.
Resolution number
Agenda
4.
number 4.
Yes.
project name, and these are the contractors. Page
Yeah.
35 of that. Petitioner was the L1 malot. Lordship finds at the table bottom malot.
Mm.
The finding is effective L1 value is 2.56% above the package value. Next page. Out of the three bidders, the bids of wind power infra is found non-responsive as their quoted price is above 25%. The bid of NK power so-and-so is also found non-responsive as there is available MA, there is some calculation, rupees so-and-so after deduction of the work value is rupees 1 crore. After disqualification of the original L1 bidder, Mrs. NK, the TPC recommended the petitioner as the lowest bidder for the package at their quoted price of so-and-so. He was the L1, found to be the L1 bidder. Then the 23/9 came, This is 19th of September.
Then how there has been a loss?
Retendering, the cost of retendering. Also, that is not quantified, The cost of retendering, the delay, because it was project of rural electrification.
But you have then why you found the other two also unresponsive?
One was 25% above,
Understood. You have found them to be unresponsive.
Unresponsive.
Now, a fake document has been given. He would also have been unresponsive.
That came later on,
Understood. But how there has been a loss on you?
Because of the retendering and the delay,
So what is the loss?
The loss is not quantified.
Then
Loss is not quantified.
then
But Lordship has seen, I am not
when
required
it has been given partially and fully?
fully.
Isn't
That I
it
admit,
like- I understand that you don't have to give him reason that we are invoking it. But how much? It has to be commensurate with the loss suffered. Or
Yeah.
do something you can't, because if it was said that you could have imposed the entire, it is okay. But when the discretion has been given upon you, either to do partially or in full, don't you think that there has to be something to that effect? If we
That
go
is
as
not
per the
there,
EMD,
I cannot improve upon whatever is there, The board meeting does not say. Board meeting says that we are invoking. My learned friend has read that, that we are invoking the entire bank guarantee. So the integrity pact says either fully or partially. There is nothing on record to show that the loss has been assessed or anything. That I cannot improve upon that. But what I am on, my lord, that the integrity pact says it's a separate contract. I mean, it's a contract, my lord. It's not that something has been imposed upon you. You have read, you have agreed, you have signed it. Now, can you say that no, it is not valid? Because the integrity pact says it is
no,
valid.
he will be liable. As per the integrity pact, there is no
My lord,
quarrel.
my
I'm not on that. But how do you link it?
Link, my lord, by the ITB, my lord, because it says
Because
ITB.
you see, just for example, I'm just showing it to you.
My lord.
The ITB. Kindly come to
Right.
clause 13.1. 13.13, where? 13.6, page 31.
Yes.
It says that bid security may be forfeited.
Then ABCD.
What are the circumstances in which the bid security can be forfeited are given out here?
ABCD, my lord.
Yes, ABCD, which are saying 13.2, the so-and-so, 13.3, any bid not accompanied by bidder is acceptable, so-and-so, the bid security of an unsuccessful shall be kept as a bid security valid for a sufficient period till the performance is encouraged and so-and-so in satisfaction. The bid security of successful will be returned when the bidder has signed the contract and has furnished so-and-so. The bid security may be forfeited. Volume 1, so-and-so. If the bidder withdraws its bid during the period of the so-and-so, in case of so-and-so, if any bidder does not accept the correction, so-and-so, E,
This
in
is in
case
line
the
with the
bidder,
bank
if
guarantee
any
clauses, my lord.
fails within the specified time limit to sign the contract, no interest will be payable. So if this does not fall within 13.6, how do you exercise the power for the bid for invocation of the bank guarantee? Any other thing which has been mentioned. So you
No,
have
but
to link this with
if
this.
your lordship reads these clauses,
Hmm.
these are exactly the same as in the bank guarantee.
Understood? So that is why.
So in addition to that,
In
there is,
addition to that, something has to be shown when it can be forfeited.
because the bank guarantee says anything else in the ITB.
It says see the language out
Yes.
there in the bank guarantee. It says in any other case specially provided in the ITB, specially provided for the purpose of invocation of the bank or the bid secure, for forfeiting of the bid secure. It has to be read specifically. The word,
I've read it, man.
if you just have the word in any other case provided in the ITB, everything specially provided means there has an emphasis being given that there has to be categorically mentioned out.
The only way to link it, my lord, is that clause.
Or is it I am only making this argument?
That word is highlighted in my file.
A lot of things are highlighted in my file, but not by me, my lord. Lordship is correct. It says in any other case specifically provided for in the ITB.
So when the word specifically has been
It is not there in the ITB. But my submission is, my lord, that it has to be linked with the integrity pact.
understood, but it has to be specifically provided.
But the integrity pact, my lord, has to be read because the integrity pact is a part of the ITB, my lord. The clauses of the integrity pact have not been incorporated in the ITB because it is there in the integrity pact, not deemed necessary. So page 26, it says the bidder shall complete the accompanying integrity pact, which shall be applicable for bidding as well as for contract execution. So bidding as well as for contract execution.
No, I understand that, but the fact is, you see, a bank guarantee is a contract between you
And the bank.
and the bank. The bank would not have given you the money unless you comply with those terms.
Exactly.
How did the bank do it in this case?
My lord, I could not.
How did the bank allow the invocation
No,
in
no,
this?
there is an interim order.
There is an interim
There is
order.
an interim order.
Not
operating.
invoke.
Not in.
So how can the bank allow you? You may file any case for the purpose of getting whatever money you like.
No, that
If
is
it
a
does
different
not
thing.
come within this, you can file any other case.
I can file a civil suit. I can.
You do whatever may be, or even because you see, first and foremost, there is no contract entered into till now, except the pre.
Except
Integrity.
this, there is no conflict.
There is no. So the invocation of the bank guarantee has to be done by the bank, would be allowed by the bank, provided it complies with the terms and conditions of the bank guarantee. Because he says that I will pay the bank, or my security, the bank should keep it and pay to you, provided these are the terms on which.
Follow, man. That I follow.
So how do you invoke the bank guarantee if it is not
So
provided?
my only answer is this, my lord. Clause 14, the integrity pact. But other than that, my lord, there is no clause which specifically says that ITP that you can invoke the bid security. So it is the integrity pact on which I have to rely upon. Regarding the validity and all everything, my lord, that
And the bank guarantee has been extended.
yes, it has been. Because the interim order is conditional, that there is an interim order operating only if they extend the bank guarantee.
How long have you extended?
Since 2017, continuously getting extended.
Now, when have you extended last the bank guarantee?
That specific instruction we don't have, but there is an order of my Lord Justice Bhuyan.
My lord, that is.
Understood, but
Eight
if
four-
you have not extended, how do they invoke now? You see, the bank comes into the picture out here. Why will I recognize this? That day, in fact, I was getting a matter of a railway where a Section 9 application was moved. The petitioner district judge, he passed the stay not to invoke the bank guarantee. But he didn't say that you have to
and extend it.
extend. Appeal was filed before this court. I said now, and the appeal was filed during COVID. By the time the matter came up before this court, in the meantime, there is no bank guarantee. What to do?
If your lordship peruses the order dated 8/4/2019, my lord, of this honorable court, my lord, passed in IA 3621. There certain observations are made, my lord.
point, this court is constrained to conclude that there was no extension of the bank guarantee. In view of that, it is clarified that the interim order staying does not operate any further. It is also taken note of that when the matter was taken up on Iman A. Sharma had made a submission that in compliance to the interim order, the bank petitioner had already given an undertaking with respect to the validity of the bank guarantee. The statement can only be understood to mean the petitioner had extended the bank guarantee in paper, but as well no material could be produced extending the bank guarantee, and therefore the prime facie it appears a false statement is made on behalf of the petitioner. There's no cause as to why incorrect statements was made before this court on so and
That has been subsequently recalled. That
That order has been
If your
recalled.
lordship kindly see is my lord Justice Bhuiya's order, that was a miscommunication.
8/4/2019.
8/4/2019, there is an order passed in IA 3621.
8/4/2019. Yes. Let the
8/4
matter be listed in the admission column.
No, but
No, in the IA.
There was a communication gap. It was in fact extended. Eight four 2019, the last but one paragraph.
Okay, but where is the bank guarantee?
My lord, there is a letter in the IA, my lord.
To whom
There is a
this
letter in the IA, annexure 2 of the IA. It is a letter written which is taken cognizance of this by the Honorable Court, my lord. This letter is of 27/9/2018. This is to certify that the
So,
bank
so
guarantee,
it is there.
it is there, is subsisting and is in existence till further orders from the court. And that has been taken note of by the.
In fact, my lord, my specific instruction is that to protect the interest of all concerned, 75 lakhs of mine is lying with the bank. So the extension is not an issue.
No, extension is not an issue, but anyways, let me dictate.
My lord.
The instant writ petition has been filed by the petitioner. Challenging the letter dated 24/4/2017 issued under office memo number APDCL/CGM bracket RE/DDUGJY/GEN EN to Koro dash CORRES/2015-16/187 by the Chief General Manager RE APDCL insofar as forfeiture of the bank guarantee of the petition. Semicolon. For setting aside and quashing the impugned letter dated 25/4/2017 issued under office memo number APDCL/CGM bracket RE/DDUGJY/DDU/Roman 2/Hills/2016-17/79 by the Chief General Manager RE APDCL to the Allahabad Bank for invocation of the bank guarantee number 0177416 Roman I, capital I, PG 000074 dated 4/8/2016 of the petitioner, as well as for a direction upon the APDCL authorities to forbear from invoking the bank guarantee number so and so dated 4/8/2016. The facts involved in the instant case, as could be discerned from the pleadings and the materials on record, is that a notice inviting an invitation for bids was issued by the Chief General Manager RE of the respondent number 1 of the respondent number 1 for execution of the projects, that is electrification works bracket VEI bracket close of unelectrified villages of 20 village districts in Assam under Deen Dayal Upadhyay Gram Jyoti Yojana bracket DDUJJY bracket close phase 2 on behalf of the government of Assam. From the said invitation for bids, it transpires that there were 5 packages. We are concerned with which one?
Fourth.
First. In the instant the instant repetition, however, pertains to package number 4, that is DDU oblique Roman 2 oblique hills for electrification work of unelectrified villages of Dimahasau, Karbi Anglong districts of Assam, bracket SPEC dot NO semicolon no, double dot APDCL oblique DDUG JY oblique Roman 2 oblique Roman 612 oblique hills bracket close. To the said in respect to the said invitation for bids, there was an instruction to bidders bracket ITB which stipulated the various instructions for the purpose of eligibility, bid security, bid validity, etc. The petitioner, being interested, participated in the said tender process. At this stage, it is relevant to take note of where is that clause for the purpose of submission of bid? Within what time it has to be submitted?
Clause 9.2.
9.2 page.
It is at
23.
9.2? No.
no,
Nine, my lord.
clause 9,
No, no,
clause
no,
9,
no.
page 16,
Page.
page 16.
Ah.
Clause 9.1.
At this stage, it is relevant to take note of that as per clause 9.1 of the invitation for bids dated 11/7/2016, the bids were to be submitted in single sealed envelope on or before, at or before 12 hours bracket IST on 6/8/2016. It has also been mentioned that the techno-commercial part of the bid shall be opened on the same day, that is on 6/8/2016. This court further finds it relevant to take note of that on the very date, that is on 6/8/2016, the petitioner entered into a pre-contract integrity pact with the Chief General Manager RE of the respondent number 1 company. Next. It further reveals from the records that on 19/9/2016, the tender purchase committee of the respondent number 1 resolved by the resolution in respect to the package wherein the petitioner submitted his bid, that out of the 3 bidders, the bids of MS Wind Power Infra Private Limited was found non-responsive, and the bid of MS NK Power and Infrastructure Limited was also found non-responsive. And accordingly, the bid of the petitioner, being the lowest bidder, the tender purchase committee recommended allocation of the work, awarding of the work to the petitioner. It further reveals from the records that on 23rd of September 2016, it further reveals from the records that the performance certificate on the basis of which the petitioner claimed to be eligible for submission of the bid dated 30/6/2016 was sent to verification to the Office of the Executive Engineer, E. Daporijo Electrical Division, Department of Power, Arunachal Pradesh. The record further shows that on 23/9/2016, the Executive Engineer E. Daporijo Electrical Division, Department of Power, had issued a communication to the Chief General Manager (RE) of the respondent number 1, stating inter alia that the performance report in favor of the MS Poran Jyoti Soikia dated 4/11/2009 for an amount of rupees 22,14,71,979 was not issued from the said of their office. On the basis of, upon receipt of the said communication, the board of, it's board of directors or what?
No, the board meeting, madam. Same day.
Board of directors.
Board of directors.
The board of directors of the respondent number 1 in its meeting dated 23/9/2016 observed that the petitioner had manipulated the documents and observed and forced the signature of the executive engineer. And as such, the board instructed the Chief General Manager (RE) to initiate legal action against the petitioner and his JV partner MS DNG Construction for providing false information and misleading the board. It was further observed in the said resolution that an FIR be lodged in that respect, and the board opined for retendering of the said package, as the other 2 bidders in the package were also found to be non-responsive. It further reveals from the records after more than 6 months thereafter, 6 months, 23rd September, 29th March, 6 months. After more than 6 months thereafter, the board of directors of the respondent number 1 in its meeting held on 29th of March 2017 had taken a resolution which, for the sake of which, taking into account its importance, is quoted herein below. এইটো page 127 ত হা? মই এইখিনি yellow কৰি দিম ঠিক আছে এইটো forfeiture of cost of so and so and so. It further reveals that on the basis of the said resolution taken on 29/3/2017, a communication was issued by the Chief General Manager RE of the respondent number 1 corporation to the senior manager of the Allahabad Bank invoking the bank guarantee numbers so and so agote question dated 4/8/2016. It is under such circumstances that the petitioner has approached this court. They have issued a letter to you, 24/4.
My lord.
Huh?
That is the page 38 of the writ petition. That is how I came to know.
Okay. Itu tar agote line eta likhibi. Pursuant to the said board meeting dated of the respondent number 1 dated 29/3/2017, the Chief General Manager RE of the respondent number 1 issued a communication to the petitioner stating inter alia that the board have decided to forfeit the bank guarantee amounting to rupees 75 lakhs submitted by MS Paran Jyoti JV with MS DG Construction against tender specification number APDCL/DDU GJY/Roman 2/Roman 12/Hills and package number DDU/Roman 2/Hills for providing fraudulent documents of performance certificate. Subsequent thereto, the Chief General Manager issued the communication to the Chief Senior Manager Allahabad Bank. It is under such circumstances that the petitioner has approached this court by filing the instant writ petition, challenging the communication dated 24/4/2017, as well as the communication dated 25/4/2017, and seeking a direction upon the respondents to forbear from invoking the bank guarantee dated 4/8/2016. From the records, it is apparent that on 28/4/2017, this court issued notice and further directed that until the next day, operation of the letter dated 25/4/2017 shall remain suspended, subject to the condition that within 1 week from the date of the order, the petitioner would communicate to the respondent number 1, 2, and 3, intimating that the validity of the bank guarantee in question have been extended beyond the next date so fixed. It further reveals from the records that the interim order has been extended from time to time. This court further finds it relevant to take note of a communication issued by the branch head of the Punjab National Bank dated 27/9/2018, wherein it has been provided that the lien has been marked on the fixed deposit of rupees 75 lakhs of the petitioner against the contingent future liability towards APDCL, subject to this court's verdict in the pending in the instant case. It is further certified that the bank guarantee towards APDCL for the amount of rupees 75 lakhs was subsisting, would continue to remain subsisting and in existence till further orders of this court. It further reveals from the records that the respondent numbers 1, 2, and 3 had initially filed a preliminary affidavit. For the purpose of bringing to the notice of this court various aspects of the matter which would be required for the purpose for consideration of the interim prayer. In the said affidavit, the performance certificate dated 30/6/2016, the certificate issued by the executive engineer, that the communication issued by the executive engineer E. Taporijo Electrical Division to the Chief General Manager RE dated 23/9/2016, wherein it has been mentioned that the performance certificate dated 30/6/2016 was not issued from the said office, semicolon. The minutes of the meeting of the respondent board held on 23/9/2016 as well as the pre-contract integrity pact entered into on 6/8/2016 by and between the petitioner as well as the Chief General Manager RE of the respondent number 1 were enclosed. To the said preliminary affidavit, an affidavit in reply was filed by the petitioner It further reveals that on 14th of August 2019, a detailed affidavit in reply was filed. Relevant herein to mention that in paragraph number 8 of the said affidavit in reply, the communication dated 23/9/2016 issued by the executive engineer Daporijo Electrical Division was disputed and has been stated to be an outcome of some miscommunication or some mischief played by someone to prejudice the petitioner. It further reveals from the records that on 14th of August 2019, a detailed affidavit in opposition was filed by the respondent numbers 1, 2, and 3. From a perusal of the said affidavit opposition, it is seen that the respondent numbers 1, 2, and 3 had laid emphasis on the pre-contract integrity pact entered into on 6/8/2016, which was the requirement as per clause 9.3 bracket 1 or L. Is it 1 or L? 9.3? L or 1?
The L, my lord, is ABCD.
Huh?
9.3. Is L, my lord. HIJKL.
L.
L.
9.3. L. On the basis of clause 9.3 L of the instruction of bidders, instruction to bidders, bracket ITB. And the pre-contract entering into the pre-contract integrity pact is one of the necessary conditions for the purpose of being eligible to participate in the said tender process. It has been further stated that in the said pre-contract integrity pact, which was duly signed by the petitioner, it was agreed that any breach of the provisions by the bidders or anyone employed by it or acting on its behalf shall entitle the buyer, that is the respondent number 1, to take all or any of the following actions as stipulated in clause 6.1 of the pre-contract integrity pact. It was further mentioned that clause 3.0 of the pre-contract integrity pact categorically mandated that the bidder had committed itself to take all measures necessary to prevent corrupt practices, unfair means and illegal activities during any stage of its bid or during any pre-contract or post-contract stage in order to secure the contract or in furtherance to secure it and in particular commit itself to the and to secure it. Full stop. It is the specific case as stipulated in the affidavit in opposition that the petitioner herein had submitted a fake performance certificate for the purpose of securing the contract, which comes within the mischief of clause 3 of the pre-contract integrity pact. And as such, on the basis of clause 6.1 bracket Roman 2, the respondent authorities had in its meeting held on 29th of March 2017 resolved to forfeit the entire bank guarantee of the amount of rupees 75 lakhs for providing fraudulent documents by the petitioner. Have you mentioned anything as to what loss has happened? So this is what you have stated in your affidavit.
My
Also. Okay. In the backdrop of the above facts, let this court therefore take note of the respective submissions of the parties.
In para 11 of the affidavit, my lord, there is something said about the suffering, my lord, but no loss has been quantified.
Page?
Page 7, internal page 7 of the preliminary affidavit, para 11.
Para 11, I have para 10 only. Page
That it is
7.
stated that the petitioner has committed.
Oh, wait. Huh?
Para 11,
Which affidavit you are saying?
the preliminary affidavit.
Oh, you are going to preliminary.
There is no pleading regarding financial loss. I'm sorry.
No, that is what I'm not saying that there is anything has been quantified, but it is said that we have suffered a lot.
I'll take note of this.
Smile.
In your submission. Mr. I. Chaudhary, the learned senior counsel, appearing on behalf of the petition, submitted that from a perusal of the invitation for bids, perusal of the document, namely the invitation for bids, and more particularly clause 9.1, would show that the bids were to be submitted at or before 12 hours IST on 6/8/2016. He further submitted that from a said perusal of the said clause itself, it will show that the techno-commercial part shall be open on the same day, that is on 6/8/2016. The learned senior counsel further referred to clause, where is this?
13.1, page 30.
Mr. Dekha, kindly ask your FPDCL to print out in a more bigger way these terms and conditions.
In fact, the page numbers are also.
It's very difficult.
Rather than suffering loss, my lord, they are saving money.
Huh?
Rather than suffering any loss, they are saving money like this.
They're saving money, man. They are spoiling my eyes. Yes. The learned counsel further referred to clause 13 of the instruction to the bidders which relates to bid security. Referring to clause 13.2, the learned senior counsel submitted that it is the mandate, it has been categorically stipulated as to how the bid security is required, in what form the bid security is required to be submitted, and the validity of the said bid security. Referring to the said clause, the learned senior counsel submitted that the bid security, as per clause 13.2, stipulates that it shall remain valid for a period of 30 days beyond the original bid validity period and beyond any extension subsequently requested under the ITB clause 14.2. The learned senior counsel further drew the attention to clause 14.14, which of the instruction to bidder, that is, the period of the validity of the bid, and referring to clause 14.1, the learned senior counsel submitted that the bid shall be valid for the period of 6 months after the date of opening of the techno-commercial part, that is the bid envelope prescribed by the employer pursuant to the ITB clause 20.1. The learned counsel further submits that clause 14.2 would have no application in the instant facts. It is therefore the submission of the learned counsel that as per clause 9.1 of the invitation of bids, the techno-commercial bid would be opened on 6/8/2016. And as per clause 13.2 and 14.1, the bid validity, the bid security could have been invoked, would be valid for the purpose of invocation only 7 months, only for a period 30 days after the expiry of the bid validity, and therefore submitted that the respondent numbers 1, 2, and 3 could not have exercised the jurisdiction for the purpose of invocation of the bank guarantee beyond 5/3/2017. The learned counsel further submitted that though the bank guarantee for bid security was valid up till 4/7/2017, 4/5/2017, but taking into account the terms and conditions of the instruction to the bidders, the bid security could not have been, the bank guarantee cannot be invoked beyond 5/3/2017. The learned senior counsel further referring to the bank guarantee enclosed as Annexure 3 to the writ petition had further submitted that the bank guarantee could have been invoked on the terms and conditions mentioned in the bank guarantee. He submitted that the terms and conditions that he submitted, that the bank guarantee, that the learned counsel, therefore, senior counsel, therefore submitted that the invocation of the bank guarantee by the communication dated 25/4/2017 not only is contrary to the provisions of the ITB, that is instruction to the bidder, but is also contrary to the bank guarantee in as much as the conditions on the basis of which the bank guarantee has been issued is not fulfilled. The learned counsel further, in the alternative, the learned senior counsel further, in the alternative, had also submitted that even assuming, for argument's sake, that the respondent number 1, 2, and 3 could have invoked the bank guarantee, then also, as per clause 6.1 Roman 2, the buyer had been given the discretion to forfeit either fully or partially the earnest money deposit. The learned senior counsel therefore submitted that though as per clause 6.1 Roman 2, there is no requirement to assign any reasons, but the invocation of the bank guarantee has to commensurate with the loss so suffered. Anything else?
And that the fact that discretion has been conferred to invoke partially or fully, that discretion has to be a reasonable discretion, reasonable exercise.
The learned senior counsel therefore submitted that when a discretion has been conferred upon an authority, the said discretion has to be exercised in a reasonable, the discretion cannot be exercised in an unreasonable, arbitrary, and irrational manner, which have, however, been done in the instant case. And as such, the communication dated 24/4/2017 as well as the communication dated 25/4/2017 is required to be set aside, and the respondents be also forbid from invoking the bank guarantee at 2-year submissions.
But can my presence be excused at 2 o'clock?
Why? Saturday.
That and a little bit of a medical issue, but I have this checked out.
Okay.
Your Honor, may permit me to mention one item. Actually, the connected writ petition to do with the levy of service tax on royalty payment. I've informed the other side.
It's the matter on when?
25th of August, Your Honor.
Let it be 25th.
One humble request, can it be through VC? I'm actually being led by Mr. Arvind Tatar from Delhi. So he requests that a VC link may be provided. I'll make all the requisite formalities.
Right. You see, there is no requirement for mentioning, stating all these things.
We'll-
If I am taking up the matter, I have no problem in taking it. Item 10, 11, 12, at the request of the parties, matter stands adjourned to be, no, why? On 25th, what is the matter about?
It's a matter with regard to with challenging the vagaries of certain provisions in the GST Act that levy income tax, that levy service tax on the payment of royalty So when the oil manufacturing companies extract oil,
Are you challenging the virus of the act?
Yes.
Then why is it before this court?
No, no, not the virus.
there is a very issue, sir.
Are you challenging the virus?
Yes, that
Oh,
is what
Then
I'll
it
be
is
fine.
they're challenging the applicability of that.
applicable.
Applicability is different from virus.
Applicable. There was a line of virus, but applicability. Applicability. of
Not the
act,
virus.
No, in this particular scenario.
And there is a stay.
There is a
Yes, sir.
We'll have it on 24th
24 on the hearing level.
24. Obliged.
at the request of the parties. Matters stands adjourned to 24th of August 2023, on which date an attempt shall be made to dispose of the writ.
Deeply obliged.
Mr. N. Decker, the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3. Had submitted that in terms with clause 9 .3 L is 9.3 L, na? Kindly see page 18 of the writ petition. 9.3, then L,
9.3 ABC,
page 21.
page 21 of the repetition.
9.3 L it will be.
9.3 L is a page 26, my lord. The integrity pact.
In my book, in my paper book, it is 9.3 L. Submits that in terms with clause 9.3 L of the instruction to the bidders, the integrity pact has to be attached to the techno-commercial bid.
I think it is clause 11. I think that 9.3 document is referring to. It is clause 11. Page 25, if your lordship will see.
No, I think that is the page number.
That is what the problem is.
11.
It appears to be
Section 2, which was the 11, and then 11 it starts.
No, because here it says A, attachments, you see, at page 18, 9.3 A, B, C. Then you have D, down below D. Then you have E, F, G, H, I, J, K, L.
is 9.3 L.
As per 9.3 L of the instruction to the bidder, the integrity pact is a part of the techno-commercial bid submitted by each bidder. The learned counsel therefore submits that the petitioner, in order to be eligible for the purpose of the said bid, had entered into a pre-contract integrity pact dated 6/8/2016. Referring to clause 3 of the pre-contract integrity pact, he submits that if a bidder commits any and indulges in any unfair means for the purpose of securing a contract, the earnest money, bracket the security deposit, which is required to be submitted while submitting the commercial bid of rupees 75 lakhs can be forfeited in terms with clause 6.1 Roman 2. Full stop. The learned counsel, therefore, referring to the performance certificate dated
30th of June 2016.
36 2016, as well as the communication dated 23/9/2016 issued by the executive engineer bracket E, Taporijo Electrical Division, confirming that the said performance certificate was not issued by the said office, submitted that the petition, in order to secure the contract in question, had indulged in unfair means and as such, the respondent authorities were within their jurisdiction to forfeit the earnest money deposit in terms with clause 6.1 bracket Roman 2. He further submitted that though a submission has been made that the validity pact, that the integrity pact was not holding the field at the time of invocation of the bank guarantee, at the time when the decision was taken on 29th of March 2017 for the purpose of invocation of the bank guarantee. But a perusal of clause 12 of the pre-contract integrity pact would show that the validity of the integrity pact in respect of unsuccessful bidder shall expire after 6 months from the date of signing of the contract by the successful bidder. And as such, the integrity pact was holding the field at the time when the decision was taken on 29/3/2017. The learned counsel further submitted that the learned counsel further countering the submission of the learned counsel for the countering the submission of the petitioner to the effect that the decision to invoke the entire bank guarantee was not arbitrary and was arbitrary and unreasonable, submitted that the respondent number 1, 2, and 3 suffered losses on account of going for retender of the work, and as such, the decisions taken for imposition for invocation of the decisions were taken for imposition of the for forfeiture of the entire earnest money was in accordance with the provisions of law. In that regard, the learned counsel referred to paragraph number 11 of the preliminary affidavit filed by the petition by the respondent number 1, 2, and 3 on 1/6/2017. Anything else? Yes. I've heard that I've perused the materials on record. This court have duly perused the materials on record and have also taken note of the respective submissions made by the learned counsels for the parties. From the submissions so made by the learned counsels for the parties, it transpires that two aspects needs to be considered. The first is as to whether the respondent authorities, respondent number 1, 2, and 3, in terms with the pre-contract integrity pact, could forfeit the earnest money deposit and or the security deposit oblique the performance bond in terms with clause 6.1 Roman 2 in the facts of the instant case. And the second aspect is as to whether the respondent numbers 1, 2, and 3 could invoke the bank guarantee in question. The learned senior counsel appearing on behalf of the petitioner this court have perused the integrity pact, a pre-contract integrity pact. From a perusal of clause 3.0, it is clear that if a bidder commits itself to take all measures necessary to prevent corrupt practices, unfair means, and illegal activities during any stage of its bid or during any pre-contract or post-contract stage in order to secure the contract or in furtherance to secure it, in terms of clause 3.0 of the pre-contract integrity, it is the mandate that the bidder has to commit itself to take all measures necessary to prevent corrupt practice, unfair means, and illegal activities during any stage of the bid or during any pre-contract or post-contract stage in order to secure the contract or in furtherance to secure it. The bidder, that is the petitioner herein, by entering into the pre-contract integrity pact, have duly committed that it have not used any unfair means for the purpose of securing the contract in question. However, a perusal of the, from the performance certificate dated 36/2016, as well as the communication 36/2016, which is the document on the basis of which the petitioner claims to be eligible and on the basis of which the petitioner had submitted the bid, have been stated by the issuing authority of the said certificate to be a certificate not issued by the said authority. The learned counsel appearing on behalf of the petitioner, though submits that there has been a communication error and the said communication dated 23/9/2010, 2016 is disputed. But the fact remains that as on today, the performance certificate dated 30/6/2016 have been disowned by the authority who have issued it. Now coming to clause 6 of the pre-contract integrity pact, it stipulates that if any breach is committed by the bidder or anyone employed by it or acting on its behalf, the buyer, that is the respondent number 1, would be it would be within the jurisdiction of the buyer, that is the respondent number 1, to take any of the actions as stipulated in subclauses 1 to subclause 10 of clause 6.1, as well as clause 6.2. During the course of the arguments, it has been submitted by the learned counsel appearing on behalf of the respondent number 1, 2, and 3 that the said respondents have taken recourse to clause 6.1 Roman 2. Taking into account its importance, this court therefore reproduces clause 6.1 to the Roman 1 to Roman 2. Roman 2. The page 118 of. From a perusal of the above quoted clause, it would be seen that the earnest money deposit bracket in pre-contract stage and or security deposit oblique performance bond after the contract is signed shall stand forfeited either fully or partially as decided by the buyer, and the buyer shall not be required to assign any reasons therefore. A reading of clause 6.1 Roman 2, and more particularly the earnest money deposit bracket in pre-contract stage, has to be meant that it is the bid security. So submitted in terms with clause 13.0 of the instruction to the bidders. This court further finds it relevant to take note of Annexure 3 to the writ petition, which is the bank guarantee in question for bid security. From a perusal of the said bank guarantee, it shows that the Allahabad Bank at Guwahati Lakhtokia branch had issued the said bank guarantee and undertook to pay to the employer, that is the respondent number 1, upon receipt of its first written demand owing to the occurrence of any of the conditions or their combinations, and specifying the occurred conditions or condition or conditions. The said conditions have been enumerated in the said bank guarantee as clauses 1 to 6. Taking into account its importance, the said conditions are reproduced herein under page 37 of the. A perusal of the said conditions quoted herein above would show that they are parameteria to the conditions mentioned in clause 13.6 of the instruction to the bidders. Except there is an additional condition at clause number 6, which states in any other case, specially in bold provided for in the ITB. It is relevant to take note of that clauses 1 to 5 is not applicable to the instant case. as it is the admitted stand of both the parties. Clause number 6 stipulates that the bank guarantee can be invoked in any other case specially provided for in the ITB. The learned counsel for the respondent number 1, 2, and 3, though submits that the integrity pact is a part of the ITB. And as such, the conditions mentioned in the integrity pact has to be brought within the fold of the ITB. The said submission, though at the first blush looks attractive, but the fact that the word used in clause 6, inverted comma, specifically provided, words used in the clause 6, specifically provided for in the ITB, inverted comma, mandates that it has to be specifically provided in the ITB as to when the bid security can be forfeited. Under such circumstances, in the opinion of this court, that although the respondent number 1, 2, and 3 would be within its powers to exercise the power within its powers to forfeit the earnest money deposit in terms with clause 6.1 Roman 2. But in view of the conditions mentioned in the bank guarantee, the said bank guarantee cannot be invoked as there is nothing mentioned in the ITB that for violation of the pre-contract integrity pact, the bid security can be forfeited. The second aspect of the matter, which also requires consideration, is as to whether the respondent authorities were justified in forfeiting the entire, in taking steps for forfeiting the entire earnest money deposit. That is 75 lakhs. Though Clause 6.1 Roman 2 confers a discretion upon the respondent authorities to either fully or partially forfeit the earnest money deposit. It is further seen from clause 6.1 Roman 2 that no reasons have to be assigned for the purpose of forfeiting of the earnest money deposit. But the fact as to whether the authorities concerned have exercised the discretion in a proper manner, but the fact as to whether the authority, that is the respondent numbers 1, 2, and 3, which is a state under Article 12 of the Constitution, have exercised the discretion in a proper manner for the purpose of invoking, for the purpose of forfeiting the entire earnest money deposit, would be a consideration. Can be looked into in exercise of the powers under Article 2 to 6 of the Constitution. This court had perused the minutes of the meeting dated 26/9/2023, as well as the minutes dated 29/3/2017. There is no decision, there is nothing mentioned therein as to why the entire earnest money deposit was sought to be forfeited and not partially. This court at this stage finds it relevant to take note of the submission of Mr. I. Chaudhary, the learned senior counsel, wherein he submitted on the basis of a judgment of the division bench of this court in the case of Food Corporation of India versus Sujit Roy, reported in 1993, 99-3 GLT 481. Which is to the effect yes, which paragraph?
The last paragraph. In fact, the second last page.
Yes, where?
At the bottom, fifth line from the bottom, Lordship.
But as has been held by us above, until the offer submitted by IA was accepted by IA, there is no contract between the so and so, and therefore no loss on account of the breach of contract between the parties and so and so. Because of. At this stage, therefore, this court finds it relevant to observe, take note of the submission of the learned counsel, senior counsel appearing on behalf of the petitioner, who submits that taking into account the power conferred, the discretion conferred for the purpose of forfeiting the earnest money deposit, which is at the time of a pre-contract stage, and a discretion being conferred upon the authority to either fully or partially forfeit would show that the said forfeiture has to commensurate with the loss suffered by the respondent numbers 1, 2, and 3. On account of the fault of the petitioner. It is the further submission of the learned senior counsel that there is no material that from the minutes of the meeting dated 26/9/2016, as well as the minutes of the meeting dated 29/3/2018, 17, there is nothing on record to show as to why the entire amount has been forfeited. It has been further mentioned that there is also no pleadings as to what loss has occasioned to the respondent numbers 1, 2, and 3. For which the entire earnest money deposit was sought to be forfeited by invoking the bank guarantee. The learned, on the other hand, this court also finds it relevant to take the submission of Mr. N. Decker, the learned counsel, appearing on behalf of the respondent number 1, 2, and 3, who submits that on account of the petitioner, the entire package had to be retendered. Which had caused delay as well as substantial loss and as well as delay and what, Mr. Decker?
Paragraph 11, my lord. Delay and loss.
Loss.
The word was suffering there. In that paragraph 11, the word used is suffering. Loss is not been used.
You could have used some more better thing. Delay to be retendered, for which it had caused delay and loss to the respondent numbers 1, 2, and 3. This court is of the opinion that except the vague statement made in paragraph number 11, that certain loss has been suffered, There is nothing mentioned as to why the entire earnest money deposit was sought to be invoked, forfeited. And not any amount which should commensurate with the actual loss suffered. This court further finds it relevant to take note of that in respect to the package in question, there were 3 tenderers. In the recommendations so made by the tender purchase committee on
19-9.
19/9/2016, 2 of the bidders have been held to be unresponsive. And the remaining bidder, that is the petitioner, was recommended. Immediately thereupon, even assuming that the certificate dated, the performance certificate dated 30/6/2016 is a fake certificate. The bid submitted by the petitioner would only be taken as a bid which is unresponsive. This decision was taken on 26/9/2016 itself, whereby the petitioner's bid was also rejected in view of the purported certificate, the purported fake certificate issued by the petitioner. There's been no material shown on record or any on record that at the time of invocation of the bank guarantee, at the time of taking the decision to forfeit the entire earnest money deposit, the respondent, the board of the respondent number 1 had taken any decision, had taken into account any materials as regards the loss so suffered on account of retendering, etc. Under such circumstances, also, this court is the opinion that the resolution so adopted on 29/3/2017 to forfeit the entire bank earnest money deposit was unfair, arbitrary, unreasonable, as well as irrational. Taking into account, consequently, the steps so taken for issuance of the impugned communication dated 24/4/2017 and 25/4/2017 on the basis of the resolution, on the basis of the board's meeting held on 29/3/2017, in the opinion of this court, is also arbitrary, unreasonable, irrational, and unfair, and violates the mandate of Article 14 of the Constitution. In that view of the matter, consequently, taking into account that the petitioners, the respondent number 1, could not have invoked the bank guarantee in view of the terms of the bank guarantee, and the forfeiture sought to be made of the entire earnest money deposit without taking into consideration the loss suffered. This court is therefore of the opinion that the impugned communication dated 24/4/2023, 17, as well as the communication dated 25/4/2017, are liable to be set aside and quashed, and accordingly sets aside so and so. Before parting with the record, this court, however, observes that the respondent number 1, 2, and 3, in view of the violation of the commitment given by the petitioner at the time of submission of commitment by the pre-contract integrity pact, would be entitled to take resort to such other actions as envisaged, would be entitled to take such actions in terms with clause 6.1 and 6.2. Clause 6.1,
1 and
2, not 3.
not 3.
6.1 and 6.2 against the petitioners. Taking into account that in the meantime, in view of the pendency of the instant writ petition and the issue as to whether the invocation of the bank guarantee dated so and so could have been done or not was pending before this court, the said period shall be excluded in computing the period of limitation.
All right.
All right.
Time being item number 1.
Yeah, Bakija case.
Yes, I have communicated, and in response to my communication, they have also reverted back in my mail saying that there is some government function is happening, that is loco prio dibus. Yeah. So for that, most of the designated officers who are dealing with the files are in official duty. So they will file out immediately. But as regard that misplacing of the file, that has been denied. They said that no file has been misplaced because subsequently his application dates back to 2014 and 15. Two applications
No,
has
no.
been filed.
Are you saying that there is a Bakizai case going on?
Yes, that is going on. 103.
So you get the status of the
Status
Bakizai
of
case?
the Bakizai case I will get.
List the matter again on 9th of August 2023, on which date the learned Mr. S. Borwa, appearing on behalf of the state, shall apprise this court as regards the status of Bakizai case number
103. 103. of 2008. 103 of 2008.
103 of 2008.
Yes.
pending before the Deputy Commissioner Karbi Anglong.
Therefore,
Karbi Anglong Dip. That is the only thing he's
Yes, yes,
asking,
very
nothing
simple.
further than
Yes,
we dispose it.
Supplementary list, I don't know, 23.
Oh, this one. Yes, Mr. Bit. Where is the other person? Mr. Garodia is not from Nogao.
No,
You are there. Fantastic. Tell me, what do you have to say? Who is there? There is another one now. Who is appearing for the bank? Mr. Betala was there.
Yes,
Where,
yes.
where is he? What is this bank? Cooperative City Employees Bank.
But I appear on behalf of 5 and 6, my lord, the one-man committee, my lord, who was appointed in terms
Now,
of
who is
the
appearing for the bank?
my lord, I appear for 5 and 6.
6 and 7.
My lord, 6, 7 is the employees federation of the bank.
Employees Association.
Employees Association.
You are 6.
I'm 6, 5 and 6. my lord. 5
5 is
the one-man-
Baldev Sama, Senior Inspector.
Yes,
I know,
sir.
how can you appear for that?
My lord,
Senior Inspector of Cooperative Society, he appeared.
No, my lord. For the cooperative society, my lord, he was a one-man committee.
Understood. But then also, how can you appear one-man committee business?
My lord,
That is
because
for him.
there is an order of this honorable court, my lord, 12, 10,
For you to
2000.
appear.
My lord, for that, my lord, in that order, it was reflected that he will now enter into the shoes of the board of directors representing the bank as well as this committee. Order dated 12/10/2018, my lord.
But then also, isn't he a person who have been appointed by the authorities out there?
Authorities, absolutely,
And this is done under 41(6).
41/6.
So let him take the blame out there. What is his name? Talukdar should take it. Yes. You are for 6. You are worried that there is, for the bank, nothing has happened. There is an interim order which is affecting you.
That is effective. My lord, the appointment of the MD, that is important. I had to file an IA, wherein, my lord, the entire proceeding where a MD was to be appointed in terms of the RTI guideline. My lord, they took a stay that this is a prerogative of the board of directors.
Hmm.
So against that order, my lord, we filed a stay vacating application, and the stay was allowed with an embargo that a leave has to be obtained from the court.
Because why a writ in the nature of sorcery should not be issued for quashing and setting aside the impugn order dated 31/7 issued by the Cooperative Society and so, disapproving the annual general meeting held on so, and directing the joint so to constitute the board of directors of a one-man, one departmental officer. Impugn order dated 2/8 issued by the so by which one so has been appointed as so. Okay. Now, 2/8/2018 you were appointed.
Yes.
5.
Yes.
5 were appointed.
Yes.
Now he says that the repetition has become infructuous. How is that become infructuous?
My lord, in my respectful submission before my lord, the matter has not become infructuous. Because, my lord, they were required to set aside the impugn order of the ARC. My lord, right? The allegations has now turned up and succeeded into a form of impugn order wherein.
And
the
that's
inquiry-
when they have challenged, because as of now, there is no new body formed.
No, my lord. Nothing.
So if no new body is formed, a person, you are continuing
Yes, my lord.
on the basis of an order dated 2/8/2018.
Yes, my lord.
If I set aside this order,
Yes.
if I don't set aside, you will remain
I remain as.
where he is asking.
Yes.
So he may withdraw. That's his lookout.
If we withdraw, that the scenario would change. My lord, the order of this honorable court, my lord, as I was appointed as one-man committee to look into the affairs of this bank. My lord, as of, I have been representing the bank and the one-man. committee, because the
Understood,
order
but-
says,
So therefore, if he withdraws,
Yes.
matter is more resolved or not? Because
But
you
then
are
the-
to hold the election in terms with
90
41/6.
Yes. I am required to.
When are you going to hold it?
My lord, within 90 days, as.
No,
the
my lord,
broad-
in fact, my instruction is, your lordship will say, my lord, that under 41/6, it is for 90 days. But under court orders, my lord, he is continuing. Now, we are required to appoint some other departmental officer. That liberty may be granted under 41/6.
No. Why should I give you? You were supposed to complete within 90 days. And how is the court extending it? The court can't extend it. It's a statutory body. Why should the court extend unless there is some grave circumstances which have resulted in all this thing? Why should the court extend it?
No, my lord, in fact, your lordship will see, the election could not have been held, my lord, due to the pendency of this writ petition. And-
Understood. If
well-
the pendency of the election, if the election have been stayed out here by this court, it's a different thing. But then also the court cannot extend it. It is your duty to extend. You have the power to appoint. Why
Yes.
should the court extend?
No,
And the function has
your
been
lordship
given
may
to
not
him under
extend it, but what
41/6.
I'm trying to say, my lord, he cannot hold now, my lord. We will appoint, my lord, new officers under 41/6, my lord. Under 41/6, my
So
lord.
are you saying that he has no authority?
No, I'm not saying that, my lord. Because
Then
your lordship.
Why
will see-
why, if you are not saying that, why should I say that you are going to appoint somebody? Thereby, I'm saying that he should not be there. Why should I say that? If he is continuing out there, let him continue, do it. You don't want him to be there. You have some problem.
My lord.
Yes, that is why. It can't be that. I am not going to do that.
No, I will.
You
obtain
have
it.
an
No,
authority.
lordship
The
will kindly-
power is given to you. You can very well say to him,
Yeah.
that, look here, we have asked you to do it within 90
No,
days. You
our
have
problem
failed to
is,
do.
lordship will kindly say, our problem is right now we can appoint another officer under 41/6, my lord. But due to pendency of this writ petition, that was not done, my lord. Because I have instructions, my lord, that since, my lord, the writ petition is pending. So it may, my lord, entail, my lord, certain consequences, my lord. So therefore,
But
my
there is
lord,
no bar.
there is no bar, my
And
lord.
why didn't you appoint?
But
And we
having
are not
regard to-
concerned with who is it. It may be A, B, C, D. But it is the fact that there has to be a one-man committee to be
Correct.
appointed who is to do it.
Correct, my lord, the
You
moment,
do whatever you feel
Yes,
like.
yes,
I'm
no.
not saying anything.
yes, absolutely.
I am
my
not
lord.
going to say all
Yes.
this thing.
But the interim order may be vacated.
The
my lord.
moment I say that you are given the liberty to appoint means I am asking him to.
No,
remove.
lordship will not say anything, my lord. Lordship will only, my lord, vacate the interim orders, my lord. I'm only
Not
saying that.
vacating there. He is going to withdraw. Yes, withdraw.
But that embargo should be taken care of.
Which one bar?
But what they are saying. regarding-
37.
Yes.
37 is taken care of. There is a order by which you can't take any action. And what is he doing? Have you taken any action pursuant to that on these 5 lakhs?
No.
He's a one-man committee who is now taking into account everything. It is his duty to do it. And for the last 5 years, isn't it?
Yes, my lord. What?
So why you have not taken any
It
action?
was also dismissed, stay was vacated, he filed his appeal, but in fact, I was the counsel who was appearing at that point of time,
For that lawyer.
my lord, Cooperative Bank. Because that was under that management, my lord. So that has been withdrawn, my lord, the council has been withdrawn and the matter.
So you are filing this writ petition and doing it vindictively.
No, my lord,
Okay.
this has been filed earlier, my lord.
So you have taken up this matter vindictively
No, absolutely not.
for being removed.
My lord, I was representing the same authority, my lord.
Yes, what are you doing
My
with
lord,
that fellow?
my lord, the entire allegations which were against these board of directors had now succeeded and formed in the form of an inquiry report, which has been filed by the Assistant Registrar of Cooperative Societies. My brother has filed it out. My lord, these inquiries had already been turned up into my lord, finality. They have attained the finality.
What is it?
My lord, that is an affidavit filed by my brother.
No,
My
what
lord,
does
the
it
entire
say?
inquiry- Lord, these allegations, Lord, the
Of
cooperative part,
misappropriation of 5 lakhs, what is it?
those have been delved into, Lord. The entire thing and the violations of the laws, Lord, that they could not conduct the meeting, everything has been detailedly laid out in
No,
this.
Mr.
And by the
Vedra,
court.
kindly come to the point. What
I have to-
is the finding as regards that particular person? What is his name?
Ganesh Chandra.
Rahanga.
Ganesh Rahang,
Huh?
Chandra Rahang.
Some Chauhan also. No,
Ganesh Chandra
That's
Rahang.
idea.
no. Ganesh Chandra
Chandra
Rahang.
Rahang.
What is the report? Was he instrumental in the purpose of misappropriation of 5 lakhs?
Can I clarify one thing?
Yeah.
What my friend is saying is regarding a report by the registrar regarding the entire allegation as such vis-a-vis the board of directors. And what
No,
here
I'm not on that. That is not relevant. I'm only on this thing because his only objection is on this. I
Yes.
need to only take care of that.
my lord,
Otherwise, he is ready to withdraw. What about this Ganesh Chandra Rahang? Now, the matter is pending before High Court or
no,
this
my lord,
appeal.
the suit was dismissed, then he files an appeal. So that appeal was pending. At that point of time, the appeal was also withdrawn.
Then,
Then
but by then, you were not there.
not there.
He was there.
He was there.
What a minute. I'll make clarify that.
Absolutely.
The instant petition has been filed. By the petitioners who are you?
We are the board of directors, elected board of directors.
The petitioners who were by the petitioner challenging the order dated 31/7/2018 issued by the Assistant Register of Cooperative Society disapproving the proceedings of the annual general meeting of the board held on 25/5/2018 and directing the Joint Register of Cooperative Society Guwahati to constitute a board of directors of the bank by one departmental officer, as well as for setting aside the order dated 2/8/2018 issued by the Journal Joint Register of Cooperative Society, by which the respondent number 5 was appointed as the one-man committee. One-man
One-man committee.
committee. In terms with section 41(6) of the Assam Cooperative Societies Act 2007.
Seven.
As a-
Which order you are saying?
Lord, 12/10/2018. Lord. But
Yeah,
this order,
31, yes, this one.
manage the affairs of the bank until further order.
This court have duly taken note of the order dated 31/7/2018 passed by the Assistant Register of Cooperative Societies. From a perusal of the said order, it revealed that there was an adjourned AGM held on 25/5/2018, and the proceedings of the AGM were submitted before the Assistant Register of Cooperative Societies for approval on 31/5/2018. Pursuant thereto, there were various complaint petitions filed against the proceedings of the AGM. The Assistant Registrar of Cooperative Society, by the order dated 31/7/2018, disapproved the AGM of the Cooperative Society, AGM of the respondent number 6, held on 25/5/2018. In the said order, the Assistant Registrar of Cooperative Society observed that the management waited up to 25/5/2018 to complete the election of the new board of directors, whereas it should have been completed well ahead so as to ensure that the newly elected member of the board assumes office immediately on the expiry of the office of the members of the outgoing board. It was further observed that the last election of the board of directors were held on 27/5/2013. So the board of directors had not, and the board of directors, as per the assistant, as stated in the order dated 31/7/2018, did not think about the period to submit the proceedings of the AGM and getting the approval of the same as per the provisions of section 45(1) of the Assam Cooperative Societies Act 2007. It was further mentioned in the said order that some of the elected board of directors were selected from the outgoing board, including the chairman of that board. Further stated that the earlier board did not take necessary steps against Sri Ganesh Chandra Rahang for his alleged misappropriation of ₹5 lakhs on 4/7/2016. It further appears from the records that on 2/8/2018, the Zonal Joint Register of Cooperative Society had, in exercise of the powers under section 41(6) of the Assam Cooperative Societies Act 2007, appointed the respondent number 5, who is the senior inspector of cooperative societies, to perform all the functions of the board and to convene the annual general meeting of the cooperative society, cooperative city of the Cooperative City Bank Limited, to constitute the board of directors within 90 days from the date of the issue of the said order. These two orders have been assailed as above mentioned. It is further seen that this court what is this 10/10/2018? What has been stated?
Well, that notice was issued, my lord.
For what?
The election of new board of directors.
So you got to stay on that.
Yes.
But that is an interlocutory application.
Yes.
It is further relevant to take note of that this court, by an order dated 12/10/2018, had issued notice. I ask any instruction.
Yes.
This is in 2021. Where is that IA? No IA. Oh, IA.
2018, there are
No. Yeah, yeah. IA. No, it is a record show the notice issue on 12/10/2021 till 19/9/1/19. It further reveals from the records that on 10/10/2018, the managing director of the petitioner of the Cooperative City Bank Limited had issued a notice stating inter alia that the AGM of the Cooperative City Bank Limited will be held on 29/10/2018. This is for vacating. I এখন ফাইল এই করে Under such circumstances, an interlocutory application was filed being IA civil number 3768/2018 seeking the stay of all proceedings given in the notice dated 10/10/2018, including filing of nominations, holding of AGM, election of the board of directors on 29/10/2018. This court, by an order dated 12/10/2018 in the writ petition, issued notice and in the meantime state the notice dated 10/10/2018 issued by the managing director of the City Cooperative Bank Limited. Where is that interim order? Another interim. Yeah. In the meantime, no, in the meantime, no, while the instant writ petition was pending, a notification was issued on 13/8/2020 for recruitment for the post of Managing Director of the Cooperative Citibank Limited.
One four nine five.
When did you file? 1495
of 20.
Let for appointment of MD, it is IA 425.
No, no,
Eh?
before that. Before that.
No.
1495.
1495 is, yeah, good. Under such circumstances, the petitioner herein filed another application before this court for stay of the recruitment for the post of Managing Director of the respondent number 6 bank. This court, by an order dated 5/10/2020 in IA civil number 1495/2020, directed that the selection to the post of Managing Director as published by the advertisement dated 13/8/2020 shall not be finalized till the next date of listing.
That was disposed of subsequently on 17th.
It further reveals that on 17/12/2020, the said interlocutory application being IA civil number 1495/2020 was taken up. And taking into account that the earlier order dated 5/10/2020 imposed a blanket embargo on the recruitment process. This court directed the recruitment process for the post of Managing Director of the Cooperative Society or of the respondent number 6 bank, which was initiated, may go on. However, the final appointment may not be made without the leave of the court. So as of now, nothing.
I 425 of
425 was fine
Eh?
to leave the embargo. IA number 425 of 2021 was fine.
Then what happened?
So that is still pending. That is today. IA 425 of 2021.
Next. It further reveals from the records that the respondent number 6, the respondent number 5, who was the one-man committee appointed in terms with the order dated 2/8/2018.
12/10/2018.
Or 2/8?
28 of the, yes, correct.
2/8.
28 of the.
Don't confuse me.
Sorry, actually.
2/8/2018 filed an application before this court being IA civil number 425/2021. Seeking leave to allow the respondent number 5 to finalize the selection process for appointment to the post of Managing Director as per the notification dated 13/8/2020 issued by the Cooperative Citibank Limited in terms with the order dated 17/12/2020 of this court passed in IAC number 1495/2020. It, however, seems from the record that there is no order passed in the said interlocutory application.
May I point out one thing, Malad? Subsequently, what has happened, the then managing director was on, going to superintendent. And for some time, this honorable court was pleased to extend his tenure. Thereafter, my lord, the bank has appointed another GM who has been functioning as the managing director.
Anyways, the
Yes.
application is pending. Then there is another order of 10/3/22. Oh, what is this? 5/10/2020. What is this 5/10/2020? Interesting. On 22/2/2022, this court directs on 9/2/2022, the court reverses this and directs that order of Justice Surana dated 5/10/2020, which was modified to be again operational. All because of Mr. Dubey, you have done this. This needs to be finished today itself.
I am only one side of the matter, my lord. My other sides are so many. I am only one side representing petitioners.
It's
Respondents are
okay.
three sides,
Yeah.
my lord.
It was revealed from the records that the order dated 12/10/2018, whereby there was a stay of the notice dated 10/10/2018, as well as the order dated 17/12/2020, whereby leave was granted for the purpose of initiating the recruitment process for the post of managing director, whereby leave was granted to proceed with the recruitment process, but no final appointment to be made, holds the field till today. Now tell me about 31/8/7. What do you have to say? Nothing remains. The learned counsel appearing on behalf of the petitioner submits that taking into account that 5 years have already lapsed from the meeting held on 25/5/2018, which was not approved by order dated 31/7/2018. The petitioner herein would not insist upon the challenge to the order dated 31/7/2018 whereby the approval was not granted. The petitioner, however, submits that as regards the observations made in the order dated 31/7/2018 to the effect that no action was taken by the previous board of directors against Sri Ganesh Chandra Rahong for his alleged misappropriation of rupees 5 lakhs is incorrect. Inasmuch as steps were being taken against Sri Rahong and the said Sri Rahong had challenged the decision of initiating disciplinary proceedings against him by way of a civil suit being registered and numbered as title suit number 42/2017, which was pending at that relevant point of time before the court of the Munsif number 2 Kamrup Metro at Guwahati. The learned counsel for the petitioner further submits that in the meantime, further submits that there was also an order of injunction restraining the bank from taking any action at that relevant point of time. The learned Mr. R. Dubey, the learned counsel, further submits that in the meantime, after the one-man committee, that is the respondent number 5, had taken over the management, the said suit, being title suit number 42/2017, had already been dismissed, and thereupon an appeal was filed, which was also withdrawn. He therefore submits that the statement made in the order dated 31/7/2018 to the effect that no steps was taken against Sri Ganesh Chandra Rahong needs to be expunged, as it may be act prejudicially to the interest of the board of then existing board of directors. Mr. H. Betala, the learned counsel appearing on behalf of the respondent number 5 and 6, submits that yes, when are you holding the election?
But within a period of 90 days from the date you
Submits that in view of the pendency of the instant writ petition and there being a stay to the notice issued on 10/10/2018, the one-man committee, that is the respondent number 5, could not take any decision, could not take steps for holding the elections as is required under section 41(6) of the Act of 2007. He submits that if the embargo which is there on the basis of the orders passed by this court are lifted, the respondent number 5 shall take appropriate steps in that regard.
My lord, may I submit one thing? My lord, under section 41, since my lord, the registrar is the ultimate authority, lordship will say, my lord, respondent 2, that is the register, he will ensure, my lord, of holding of the election in AGM under 41(6), my lord. That would, my lord, in fact, rule out all confusion, my lord.
No, that is why you will be appointing,
Right.
you do whatever you
Yes,
like.
yes, correct.
We,
If
today
this,
is
my
what
lord,
date?
if this observation
No,
goes, my lord,
today is
from
what
this
date?
out, my
No,
lord.
I will give it.
Yes, yes.
Today is what date?
5th of August.
5th of August.
Right.
Let's take it from 9th.
9.
Hold the elections by 8, 9 to 10. Hold it by 9th of November.
Correct, my lord. Only 15 days notice is necessary.
Or 9,
So
then you
within
hold it
45
by.
to 50 days, my lord, it can.
No.
This would entail.
No. You have hold the election, whatever.
Yes,
You have
yes,
to do it
correct.
by 90 days.
Correct, my lord. Lordship will give that.
So you finish the entire process by 17th of November.
Correct, my lord. Yes.
No
Lordship will
notice
code it.
and all.
Yes.
I'm coming in 5 minutes. Wait, Manu. I'll just keep it. Others may go, except that matter, criminal matter. Oh, yes, your matter. I'll take it. Others may go. Because this I'm finishing up. Because this needs to be finished. Cooperative society and fishery. That day I was telling Mr. Bonik, you see, unless you file 15 petitions in one fishery.
Tender matter. Tender matter.
No, tender is fishery.
Fishery.
15 petitions is the must. Remission, I am not getting. Area not being given. This is the first case not given, second case not given and all. Unless you have 15 petition, you can't say that you are the owner of a fish.
My friend is
Mr. S.K. Talukdar, appearing on behalf of the Corporation Department, had referred to the provisions of section 41(6).
41(1) first, my lord. 1 and 6.
Huh?
1 also, my lord. 1 says, my lord, the entire, my lord, election relating, my lord, activities shall vest in the register. 41(1). Superintendent's direction and control and conduct of all election, my lord.
Referring to section 41(6) of the Assam Cooperative Societies Act 2007, had submitted that when the board fails to arrange for holding the elections before the expiry of the term of the board or the delegates, or where there is no director remaining on the board, it is the register who shall convene a general meeting by appointing an officer of the cooperative department for constitution of the board within 90 days from the date of such appointment, and the officers so appointed shall perform all functions of the board during the said period of 90 days at the cost of the society. The Learned Counsel further, referring to clause 41, section 41(1) of the said Act of 2007, submits that it is the superintendent's direction and control and preparation of electoral rolls for and conduct of all elections to the cooperative society vest upon the register. The Learned Counsel therefore submitted that if this court fixes a particular period, the register of cooperative society shall do the needful for holding the meeting, for
AGM
convening the general meeting,
stroke
as well
election.
as the election of the board of
Respondent
directors, no,
Respondent
election
six.
of
Respondent 6, my lord. Cooperative City Bank Limited.
of the respondent number 6. He further submitted that as the power exercised by the respondent number 5 is on the basis of a delegated power, is on the basis of orders passed by the delegate of the respondent of the register of cooperative society. It is the register of cooperative society who has the authority and jurisdiction in terms with the Act of 2007 to convey the general meeting and as well as hold the elections of the respondent number 6.
Correct.
Garodia. PK. The learned counsel appearing on behalf of the respondent number 7 and 8 submitted that the petitioners herein, having not taken any steps against Sri Ganesh Chandra Rahong, who was guilty of misappropriation of rupees 5 lakhs. The petitioners herein are disqualified in terms with section 37, 37 or
E.
42, 40, 44A,
No, 37E, my lord.
44,
No, 44 is with regard to different, my lord. Here 37E, my lord.
in terms of section 37E
My lord.
of the Act of 2007. Upon hearing the learned counsels for the parties and taking into account the specific submission of Mr. R. Dubey, the learned counsel appearing on behalf of the petitioners, to the effect that that the petitioner do not insist upon the disapproval, the non-granting of the approval by the Assistant Register of Cooperative Society to the meeting held on 25/5/2018.
Due to efflux of time. Due to efflux of time.
Due to a flux of time. This court is not interfering with the order dated 31/7/2018. However, this court also finds it relevant to take note of the submission of Mr. R. Dubey to the effect that the order dated 31/7/2018, wherein it has been held that the petitioners have not taken action against the said Ganesh Chandra Rahong, may act prejudicially to the interest of the petitioners. This court finds it relevant to take note of that the petitioners at the time of holding the post of directors in the board of the respondent number 6 had duly taken action against the said Ganesh Chandra Rahong by initiating departmental proceedings against the said person. It is on account of the injunction order passed in title suit number so and so, 42 ne ki baat hai, so and so, that the petitioners could not take further steps against the said Ganesh Chandra Rahong. It is further relevant to take note of that pursuant to the dissolution of the board of directors and the appointment of the one-man committee, the said suit was dismissed and an appeal so filed was withdrawn. Under such circumstances, it is the opinion of this court that the said remark made in the order dated 31/7/2018, stating that the petitioners, stating that the board did not take any necessary steps against Sri Ganesh Chandra Rahong for the alleged misappropriation of rupees 5 lakhs requires to be expunged. And accordingly, the said sentence in the order dated 31/7/2018 is expunged from the said order.
Can I add one?
It is further,
Can I add one thing?
don't need anymore.
Section is from 7 and 8 together. I have made a specific amendment to the effect that
I have seen it. I don't want to mention all those.
My lord.
unless-
not,
You are saying about respond number 8,
yes,
not necessary. Do you invite both? Why you allow later on Mr. P.K. Garodia to complain that I, in my absence, all this thing?
no, my lord.
Anyways, this court further finds it relevant to take note of that the order dated 2/8/2000, but that by order dated 2/8/2018, the one-man committee was appointed. The mandate of section 41(6) appointed in terms with section 41(6) of the Act of 2007. A perusal of the said section stipulates that the said one-man committee is required, that the register of the cooperative society through the one-man committee is required to hold the general meeting as well as the elections to the board within 90 days from the date of the appointment. This court duly takes note of the submissions made by Mr. H. Betala as regards the difficulties faced for not holding the meeting on account of the proceedings being pending and the various interim orders being passed. Be that as it may, it can, taking into account the appointment, taking into account that the Act of 2007 stipulates that the cooperative society be that as it may, taking into account that it is the board of directors who should be running the management of the cooperative society in terms with section 35 of the Act of 2007, and the period of and the period within which and the and the appointment of a one-man committee is only as an interim for the purpose of holding the meeting and for convening the meeting and holding the elections. This court is of the opinion that the that the register of the cooperative society is required. The register of the cooperative society who is duty bound in terms with section 41(1) and 41(6) of the Act of 2007 to take appropriate steps for the purpose of convening the meeting, general meeting, as well as the holding the elections of the cooperative society in question. Accordingly, this court, in the interest of justice, directs the register of cooperative society to take appropriate steps so that the meeting of the board of directors, a meeting of the cooperative society, general meeting of the cooperative society is held on or before 17th of November 2023.
What will say AGM stroke election?
Hmm?
AGM stroke election.
I said that the general meeting, convey the general meeting as well as the elections of the cooperative society of the respondent number 6 within on or before 17th of November 2023. With the above observations, the instant petition stands disposed of Full stop. The interim orders which have been passed as referred to here in above stands vacated.
Deeply above.
I say substitute.
Obliged.
Cooperative society means IS. Settlement means
Today it is established, my lord.
eh?
Today it is established. So many IS, my lord.
Many it will happen.
Obliged.
And number 24, 25.
Yes. Where is the order of 156.3?
Page 76.
Hmm?
Page 76.
Page, which one? 1989?
198.
Yes, which one?
Page 76.
Page
76.
70.
76.
76. Yeah. So on the basis of this, FIR was lodged.
My complaint was registered.
Your complaint was filed.
My complaint was. the complaint
You
was
filed the complaint, somebody filed the complaint,
Complaint by private response. Private.
private persons, and the order was passed on 28/2013. And thereupon, the FIR was lodged thereafter.
That was registered on 22/8/2013.
Yes, that is what after 2 days,
After 2 days.
FIR was registered. Then
Then my lord, preliminary inquiry report was submitted to the special court.
Hmm.
That is page 84.
Then
Again, my lord, it was directed page 88.
order was passed, 88.
88.
Submission of report so and so, peruse the copy of the shown that he has made certain progress regarding he is directed to complete as soon as possible, complete it for state court. Then
Then my lord, this final report was submitted page 89.
final report or it's a charge sheet.
Sure, it can be said touch.
Huh?
Touch.
It's a charge sheet given.
This is the final PR, preliminary report.
So then
At
from
the top,
statement
first
it
and
is
final
certain as
PR.
so and so, and forwarded to the authority for the release of funds with regard to so and so is liable to prosecute under so and so. I therefore suggest submit CS in the case against the accused E. Ismail and Kulendra Pratap, which may be approved. Then what?
That my lord, this sanction,
Kindly
sought for.
accord sanction for prosecution against so and so and so and so and oblige. So they have asked for prosecution.
Might.
Now prosecution sanction granted.
not granted, we challenge this letter.
Huh?
We challenge this letter before the honorable court.
And this court stayed it.
Stayed.
Yes, tell me.
But I have checked the position, Lordship. Yesterday, Lordship has indicated that the
Mr. Nath,
L. Narayana Swami,
that is a very difficult, that judgment categorically points out that question only.
L. Narayana Swami is not the final position.
How? Anything else?
Yes,
That is what I was thinking.
Lordship.
Because my thing is how cognizance, because you see, if you see that judgment which have been enclosed,
Yes.
there all along it has been stated this, that pre-cognizance, post-cognizance means for the purpose of cognizance it is required, not for the pre-cognizance stage it is not required. But however, this judgment and that judgment which I gave you,
Lordship.
2016,
Lordship.
it says otherwise.
Yes. Well, this aspect has been taken care of. Lordship may kindly have 2018 5 SCC 557.
Yeah, there should be some 2018.
5 SCC 557.
Maybe.
Now, well, in this case, the matter has been Manju Surana versus Sunil Arora. The matter has been now referred to the larger bench. Matter has been sent this entire issue because in this case all the cases right from the earlier cases and in paragraph 26, 27, Lordship will find the Anil Kumar case which they have relied, and the para 30 L Narayana Swamy, the 2016 case, those all are considered, and ultimately paragraph 31, 30 onwards, 31 onwards, and 35 the issue has been referred to a larger bench. And I have checked the status of larger bench before it is still pending. Larger bench has not decided. Lordship, I'll just read the paragraph.
Understood, but the problem is
Lordship.
you also know the law.
Lordship.
The larger bench, till the larger bench, mere pendency before the larger bench would not help it. That is another law.
Lordship, paragraph 8, kindly see, paragraph 8, 9.
Of?
Paragraph of this decision, paragraph 8.
Yes, Prasan Bhushan.
Mr. So-and-so learned counsel appearing for the appellant sought to question the view taken in Anil Kumar and L. Narayana Swamy versus State of Karnataka following the earlier judgments. The substratum of the argument is that the requirement of prior sanction or prosecution against the public servant would arise only when cognizance is taken, while no such sanction was required at the stage of setting into motion an investigation under Section 156 CRPC. It was thus contended that the observations in these two judgments are par incurium or in conflict with the long line of earlier judgments on the question as to when the cognizance can be stated to have been taken. Paragraph 9, the section 19 has been quoted. Then para 10, 190, and then Lordship may kindly come to paragraph 17.
Yeah.
Para 17.
17.
17. Lordship. Here, my lord, judgments on the nature of proceeding before an inquiry under section 156.3 CRPC has been discussed. All the decisions of the Supreme Court earlier. In R.R. Chatri versus State of UP, a three-judge bench of this court, in the inception years of this court, referred to Gopal Marwari versus King Emperor Kwa. The observations that the cognizance indicates the point when a magistrate or a judge first takes judicial notice of an offense. This was different from initiation of proceedings. The word cognizance was somewhat of an indefinite import and perhaps not used exactly in the same sense. Therefore, thereafter, it proceeded to notice the observations of Dasgupta J. In Superintendent and Remembrance of Legal Affairs versus Abani Kumar Banerjee, where observations were made to the effect that what is taking cognizance has not been defined in CRPC, but it could be said that any magistrate who had taken cognizance of any offense under section 190A1A CRPC must not only have applied his mind to the contents of the petition, but must have done so for the purpose of proceeding in a particular way, as indicated in the subsequent provisions of the chapter. Proceedings under section 200 and thereafter under section 202. However, when the magistrate applies his mind not for the purpose of proceeding under the subsequent sections of the chapter, but for some other kind, ordering investigation under section 156.3 or issuing a search warrant for the purpose of investigation, he could not be said to have taken cognizance of offense. The Supreme Court gives its imprimatur to these observations. Then paragraph 18, 19, ultimately Lordship will find para 26.
Let's see 24.
24. In Subramaniam Swamy versus CBI, it was observed that section 156 enables an officer in charge of a police station to investigate a cognizable offense. Insofar as non-cognizable offenses are concerned, it was found that the police officer, by virtue of section 155 CRPC, can investigate it after obtaining appropriate orders from the magistrate, having power to try such case or commit the case for trial regardless of the status of the officer concerned. In view thereof, the scheme of section 155 and 156 CRPC was held to indicate that the local police may investigate a senior government officer without previous approval of the central government. The Constitution bench, while dealing with the inquiry and investigation under the PC Act, held that there was no basis to classify the two sets of public servants differently on the ground that one set of officer is decision-making officer and not the other set of officer. Despite the opposite catena of judgment, a different path has been traversed in two judgments of this court where the offenses alleged under the PC Act read with IPC. In Anil Kumar versus MK Ayappa, they have relied this case. The court proceeded to examine whether the magistrate, while exercising his powers under section 156(3) CRPC, could act in a mechanical or casual manner to go on with the complaint after getting the report. In that context, a reference was made to an earlier judgment in Maqsood Said versus State of Gujarat, where it was observed that there was a requirement of the application of mind by the magistrate before exercising jurisdiction under section 156(3) CRPC. Therefore, thereafter the bench proceeded to draw a conclusion that a special judge magistrate cannot refer the matter under the section 156(3) CRPC against a public servant without a valid sanction order. Then in the next para, the bench further proceeded to examine whether the order directing investigation under section 156(3) CRPC would amount to taking cognizance of the offense, since a contention was raised that the expression cognizance appearing in section 19(1) of the PC Act would have to be construed a post-cognizance stage and not pre-cognizance stage, and therefore the requirement of sanction does not also arise prior to taking cognizance of the offense of the PC Act. Insofar as the expression cognizance which appears in section 197 CRPC was concerned, a reference was made to the judgment in state of UP versus Parasnath Singh. In that case, it was observed that the jurisdiction of a magistrate to take cognizance of any offense is provided by section 190 CRPC, and so far as the public servant was concerned, this was clearly barred by section 197 CRPC unless the sanction was obtained from the appropriate authority. After referring to certain other judgments on the issue of purport and meaning of the word cognizance, it was concluded that cognizance has a wider connotation and is not merely confined to the stage of taking cognizance of the offense. The bench proceeded to discuss section 119(1) of the PC Act as also section 19(3) of the PC Act, which read as under. This section has been quoted. Then para 29, it was sought to be contended that the requirement of section was only procedural in nature and hence directory, or else section 19(3) of the PC Act would be rendered odious. This contention was not found acceptable as subsection 3 of section 19 of the PC Act had an object to achieve, which applies only to circumstances where a special judge has already rendered a finding, sentence, or order. This would not mean that the requirement to obtain sanction was not a mandatory requirement. In the absence of prior sanction, it was observed that the magistrate cannot order investigation against the public servant even while invoking power under section 156(3) CRPC. In L. Narayana Swamy versus State of Kerala, Karnataka, the the judgment in Anil Kumar versus MK Ayappa was followed. After discussing various other pronouncements, it was concluded that even while directing an inquiry under section 156(3) CRPC, the magistrate applies his mind to the complaint, and therefore it would amount to taking cognizance of the matter. Mr. So and so, ultimately, my lord, the para 32, we have examined the rival contention and do find a divergence of opinion, which ought to be settled by larger bench. There is no doubt that even at the stage of section 156(3), while directing an investigation, there has been an application of mind by the magistrate. Thus, it may not be acceptable position to contend that there would be some consequences to follow, where the magistrate to act in a mechanical and mindless manner. That cannot be the test. The category of judgments on the issue as to the scope and power of direction by a magistrate under chapter 12 and 14 is well established. Thus, the question would be whether in cases of PC Act, a different input has to be read for the power to be exercised under section 156(3) CRPC. That is, can it be said that on account of section 19(1) of PC Act, the scope of inquiry under section 156(3) CRPC can be said to be one of taking cognizance, thereby requiring the prior sanction in case of a public servant? It is true to say that prior sanction to prosecute a public servant for the offences under the PC Act is a provision contained under chapter 14 CRPC. Thus, whether such a purport can be imported into chapter 12 CRPC while directing an investigation under section 156(3) CRPC merely because a public servant would be involved would beg an answer. The apprehension expressed by learned ASG possibly arises from the observations in Suresh Chandra Jain versus State of MP, followed in Muhammad Yusuf versus Afaq Jahan. Thus, the observations are to the effect that even if a precognizance stays under section 156 CRPC, it is up to the magistrate to direct the police to register an FIR, and that even if the magistrate does not say in so many words while directing investigation under section 156(3) of the code that an FIR should be registered, it is the duty of the officer in charge of the police station to register the FIR regarding the cognizable offense disclosed by the complainant, because that police officer could take further steps contemplated in chapter 12 of the code only thereafter. The complete controversy referred to aforesaid and a conundrum arising in respect of interplay of the PC Act offences read with CRPC is thus required to be settled by a larger bench. The papers may be placed before the Honorable Chief Justice of India for being placed before a bench of appropriate stand. And this is an issue particularly in that case because the respondent number 1 he sought deletion of his name from this case. That has been from para 36 to
What did the Supreme Court do in that case then?
but I have checked the reference it's pending, I find.
No. Thereafter, paragraph 36 onward.
36 onwards said that no, respondent number 1 may not be is not allowed for deletion of his name.
Huh?
He has prayed for deletion. I'm reading paragraph 37 onwards.
No, because
onwards.
why I'm saying is,
Logic.
what happened thereafter in that case?
He remained in that case. He has prayed for deletion of his name. Respondent number 1, he prayed for that his name should be deleted from the array of respondent. Honorable Court said not at that stage.
Let's see.
It is denied. It is denied. No. We have passed a detailed order making a reference to a larger bench insofar as the main matter is concerned. It may be noticed that in the present special leave petition, notice was issued to the respondents except respondent number 4, since the proceedings before the magistrate at that threshold were directed to be kept in abeyance without notice to the respondents, and thereafter the revision petition was dismissed in limine by the High Court. The occasion for respondent number 1 to have knowledge of the proceeding did not arise. Respondent number 1 seeks deletion from the array of parties in these proceedings as he has been wrongly arrayed as a party. The aforesaid plea is predicated on the averment in the complaint itself, which seeks to make a grievance over the action of the Principal Secretary, Public Health and Engineering Department, in which capacity respondent number 1 is stated to have been arrayed. It is averred in the application that respondent number 1 was serving as a secretary and principal secretary to the Chief Minister and not as a principal secretary PHED. In fact, the officer worked as the principal secretary PHED has not been arrayed as a respondent, there is no allegation made against the secretary, principal secretary to the chief minister. The allegation is of collusion of the respondents. In terms of the averments or in the application, respondent number 1 sought to point out that there are only 2 references to him as accused 1, para 4, Roman 4, and para 8. These are in context of inviting tenders, shortage of budget for running the current projects, and the report of stated accused 1 as the principal secretary. The second reference is to the stated accused 1 as the chief secretary who wrote a proposal to the finance
Can
department.
you come to
wherever-
paragraph 41?
Logic.
This is relevant because
Logic. On 28 on 22 2018, we had issued direction for the appellant to place on record the material placed before the magistrate in support of the complainant, indicating the alleged involvement of respondent number 1. In response thereto, a supplementary affidavit was filed by the appellant. On this behalf, a file noting on 9/5/2008 is referred to. The discussion was with regard to the finding of the same project, and the presence of respondent number 1 is noted. Though undisputedly my notes are not signed by him while they are signed by other officers, it has been averred that since the principal secretary to the chief minister had no role to play in the discussion, why was he, respondent number 1, present? We may also note the submission of the learned counsel for respondent number 1 that in case a situation arises where the magistrate has to proceed on the complaint under section 156(3) CRPC, and during investigation some material is found, the council cannot really object to the inclusion of the name of respondent number 1 at that stage. However, inclusion at this stage is stated to be without any material and is an embarrassment considering the constitutional position held by the respondent number 1. We have given a thought to the respective plea of the parties. No doubt, the process under section 156 CRPC is only one of investigation. The larger question of whether any such direction can be issued without prior sanction has to be referred to a larger bench, where the appellant to succeed and where the matter go back to the magistrate, and the magistrate after application of mine forms an opinion to direct investigation by the police. It would be always open to the magistrate to include the name of respondent number 1 if such material is found against him. Merely because the appellant has roped in respondent number 1 in the complaint is not sufficient ground to allow his name to be included as such. The complaint is categorical. The role of secretary, PhD, and the principal secretary has been questioned. This is the mindset with which the complainant knocked the doors of the criminal courts. There was no allegation in respect of any role played by the secretary, principal secretary to the chief minister. It cannot be said to be a mere misdescription of name, which can be corrected. It cannot be the stand of the appellant that willy-nilly somehow respondent number 1 must remain arrayed as an accused in the proceeding, even though the proceeding before the magistrate are at the stage of only whether there should be a direction for investigation or not. It is not that every officer in the government has to be arrayed in respect of any role performed or not. The mere presence in one meeting of respondent number 1, and that too when he was not a signatory and really had no role to play in that capacity, as apparent from the minutes, cannot be now used to justify his name being included as an accused. This is clearly an afterthought. It is not for the appellant to question as to which officer should or should not be present. We are thus,
paragraph 45 is the most relevant.
logic. We are thus of the view that respondent number 1 needs to be struck off from the array of parties, both in the present proceeding and consequently in the complaint. We, however, make it clear if a situation arises where investigation is directed under section 156(3) CRPC and some material comes to light to array respondent number 1 as an accused, and our order would not come in the way. Well, here Lordship will find
Now let's see the complaint.
yes.
In truth.
Well, kindly see the complaint. Complaint is not against the petitioner.
Then if it is not,
Lordship.
it is therefore most respectfully, Your Honor, would pleasure be pleased to admit this complaint, issue a rule calling upon to please to issue and so. Corrupt official Sri Anup Kumar Gohai, the then Chief Engineer Minor Irrigation and presently working as the Chief Engineer so and so.
Correct.
So the allegation is against them.
Allegation is against the chief engineer.
Understood.
Correct.
So and during the investigation, they found this.
They found that the two officers, two petitioners, they were, there is some,
No, understood.
some wrong.
So
on
there's
their-
something wrong.
something.
And as such, they have submitted the preliminary report and the final report.
Yes.
Then can you say
Got
that the petitioners can be aggrieved for exercise of powers under 156(3) without even if the larger question or anything, because there is nothing out there
No.
against them in the
But-
that is why I say paragraph 45 has a lot of relevance.
Correct.
Paragraph 45 says, okay, we strike off their names from the complaint. But during the process, if it is found,
Then-
then in that case, they can ask for the sanction,
Yes.
which sanction has been asked against them.
Yes, my lord.
So
Because
against the petitioner, there was never a proceedings under 156(3).
156(3) order was not against the petitioners. That is
Ah.
what my respectful submission is. My
So
lord,
this paragraph 45 gives you the leeway.
correct, my lord.
That is why the
Correct.
larger question is there,
Yes.
whether it is there or not. But in this case, how is it going to be applicable? Because their name was never there out here.
156 order is not in respect of the petitioners. But the only after the investigation, in fact, in the first report also,
And thereafter, we are not concerned.
Okay. Got
Thereafter, now you are seeking a sanction.
we have, that is what, my lord. After the 156 order, they investigated into the matter,
And found that these petitioners
found-
are involved.
found these petitioner, two petitioners holding the public office, they are involved. Accordingly, they have approached the authority that give us prosecution. That is our case.
Now tell me
Right.
whether the police can investigate without the sanction. Yes.
Sanction is required after taking, at the time of taking cognizance. 156,
Now, that too I have understood, but
No.
these two judgments have created all the problem.
correct.
But the police can investigate if
Police-
it is a cognizable offense.
Well, even if under 156 is very clear. Na? 156 says if an information comes to them, the police officer's power to investigate cognizable offense.
So the police power is 156 is
156.
cognizable.
Yes.
If it is non-cognizable, 155.
155.
This is a case which is cognizable.
It is cognizable. Logic.
If it is cognizable, the police can investigate
Yes,
without the horse 156(3).
156 is there or not?
The
They-
horse 156(3),
Yes.
also the police can cognizate.
Police can.
Yeah. Now the complaint out here was not against them.
No.
So if the court has given this, and thereupon it was found that this has happened, and they were there, why can't paragraph 45 be taken to the effect and give that you can now proceed?
Correct, my lord. So by applying this, the taste of this case, my lord, in fact, our action.
So why
our
should we
action
go
can-
into the larger question? Because they were never, the proceedings under 156(3) were never against them.
Never against them. Therefore, my lord, they cannot take the benefit of L. Narayana Swamy.
Or anybody, anything,
This
because
question.
in view of this explaining thing,
Logic.
that was not done.
Logic.
Thereafter, if anything happens out there, they can very well bring in. And
They-
bring in how? By way of,
The investigation.
because
and-
tomorrow I may very well say that that particular person, a private person out there, has done this particular thing.
Gotcha.
I may file an FIR of 156(3).
Yes.
And later on, it is found that the DC was involved.
Only after investigation that has come out.
And then for the purpose of prosecution, they will definitely have to obtain the insult.
Yes, my lord.
But can you say then the exercise of powers under 156(3) was wrong?
In my respectful submission, no, my lord. In my respectable submission, it is
Yeah.
cannot.
That part is of course there.
Huh?
During the investigations, my lord, they have been found, my lord, their name.
No.
Now,
Therefore, I'm saying
that is-
156.3, taking into account those two judgments,
Right.
which you have relied, one and L.M.
only
Swami,
Kumar and
those say that you cannot direct when these person you require a sanction against those persons.
But one thing, my lord, whether initiation of that proceeding, that is, it starts from the complaint and 156 then come, then that initiation of the proceeding is not correct. Then whether other part can contain that aspect also. Because
Initiation of the proceed, just for example,
Ma-
that I was therefore giving that example. Let us take an example that A has a quarrel with B, saying that the B have illegally and fraudulently executed a deed of sale against me. My land, B had fraudulently executed the deed of sale. Police is not doing anything. I can move under 156.3. No quarrel. There, no problem. The court passes an order. Okay. Investigate and for FR. During investigation, it is found out that the circle officer, the registry, the sub-register was involved. If the sub-register is involved, they said, are you going to say that that investigation is bad, taking into account that the order which was passed under 156.3 also involves or has a connotation of involving some government officials where sanction is required? No. Because this happened during the course of the investigation. And thereafter, what is required is the sanction. They will obtain sanction. If they don't get the sanction, matter ends.
It is practically not.
That is
possible.
how this particular judgment they have taken. That is why I asked Mr. Nath, what did the court do? You can't keep the matter pending for all time. So the court, what they did, there was nothing against although the respondent number 1 was in the complaint. The court said that, okay, we remove the complaint. As well as whatever has happened in respondent number 1, we remove him. And if during the investigation, if it is found anything against him, it's okay. The order which has been passed against the respondent number 1, that is why paragraph 45 is required.
45, yes.
You give it to him.
I can send it in mail. I have a soft copy.
You give that soft copy to
Look,
him.
yes.
That is why I removed the glass. See this person. We are thus of the view that the respondent number 1 needs to be struck off from the array of parties, both in the present proceedings and consequently in the complaint. That is a complaint under 156.3. We, however, make it clear that if a situation arises where the investigation is directed under section 156.3 CRPC and some materials comes to light to array respondent number 1 as an accused, our order would not come in the way.
No, come with it.
This is how it has been done. This is the same case. Their allegation is against somebody. You were not involved out there. During the course of investigation, something has been found against you. Therefore, they have submitted the report before the court, and thereupon they have sought for sanction. So what is wrong now? I would have understood your case would have been if they have been made a party, and therefore you say that those two are judgments, and this division bench judgment of the year does not override the other, and as such have been referred to a larger bench. And as such, when the question is referred to a larger bench, the law constitution bench of the Supreme Court says that the earlier judgment, which was holding the field, will hold the field. There's no quarrel with that. So therefore, the court also, I'm not on that. But in this case, you were not nothing was mentioned against you. It was against some chief engineer.
initiative.
Chief engineer. Now thereafter you got involved. If they get the sanction, it is okay. If they don't get the sanction, it is bad. This is how it is. Till it is resolved. Although I have, Mr. Hawk, I have serious doubts. Because if you see that judgment also, on top everything, Parasnath was taken, it was taken, Subramaniam Swami, everything has been taken. Last, somehow one line has been added. And in L. Narayana Swami, it's the same composition of judges. And then the question was framed that why haven't you followed that? It was binding.
In the Anil Kumar case.
Huh?
In the Anil Kumar case.
Justice Sikri was there.
Yes, my lord.
So, madam, can we wait for the, my lord, that judgment?
Why?
So, it-
Why should I wait for that? I'm not on that. We are not going. We are going by paragraph 45.
No.
Because you were not made a party here. There's nothing against you. If nothing is against you, because here the complaint is against Anup Kumar Goyal, the Chief Engineer, Irrigation Department, Government of Soil. Nothing is against you. Here they have only made. If this person comes in, it's well and good.
Then the things would have been different. In case of Gohai, things will be different.
But what, in effect, what the court did, it's a very, this paragraph 45 is something of a genius kind. That look here, we remove him from the area part. Remove him. But during investigation, if something is found out, because investigation can be done under 156 and 154, if it's a cognizable offense. If they found out, then it will follow. So thereby not making a complaint back. And the process of the investigation.
So the issue will be decided at a later point, but the investigation and everything will go on.
Anything else? Because these are matters of 2014. I'll pass the order, dismissing it.